Good morning and welcome to Foley's 2021 Annual Government Contracts webinar. This year we are doing it again solely as a webinar, and I'm hoping that next year we'll be in person in Michigan for those who want to attend in person, and we'll continue the trend of live streaming by webinar. My name is Erin Toomey, and I am a partner in Foley & Lerner's Detroit-based office, and my specialty is in government contracts. I want to spend a minute giving you a brief overview of Foley & Lerner since they are kind enough to sponsor the program today. Foley is over 175 years old, not myself, Foley. We have 21 offices within the U.S., including a significant presence in California and Florida. We have offices in Boston, Chicago, New York, Wisconsin, all over. We have 3 international offices in Brussels, Mexico City, and Tokyo. And we have attorneys that practice in all areas of law, corporate, M&A, employment law, litigation, intellectual property, and of course, federal government contracts. We work in teams with a multidisciplinary approach to help clients solve their problems and achieve their business objectives. We have been doing this seminar for I've been doing it personally for over 15 years. Foley's been doing it longer than that. And we are excited for you to join us today. Before we get started, we're going to have a few quick housekeeping items. Questions can be entered via the Q&A widget that's open on the left-hand side of your screen. We will wait and hold questions to the end of the presentation, time permitting, to make sure that we get through all the presentations and the content. If you want to follow up with any of the speakers afterwards, you will have our email addresses. Please feel free to do so. This seminar today will be recorded, and a recorded version of the presentation is going to be available on our website in the next few days. So if you miss a piece of it, or if you have any colleagues who are not able to attend today, you can forward that on to them. Also, you can download a copy of the slides in the resource list widget, and that's on the right-hand side of your screen. I find that the way we do the slides, they tend to be more detailed. We may not cover all of the content in the slides, and of course we talk about things that are not on the slides, but we make those slides so that they could be a good resource for you throughout the year. Foley is going to apply for CLE credit after the program, and to be eligible for CLE, you need to answer some polling questions throughout the program. I can't tell you in advance when they're going to be, so you need to tune in and listen closely, and when we read the code, there's going to be a place for you to enter the code. If you did not give us your CLE information when you registered, you can email it to smeeker@foley.com, and we'll distribute certificates of attendance via email approximately 8 weeks after the web conference. If after that time you don't receive it, please feel free to follow up with us. Also, if you are seeking Kansas, New York, and New Jersey CLE credit, you are required to complete the attorney affirmation form in addition to answering the polling questions. And then you can email the form to smeeker@foley.com immediately following the program. Also, there is a survey that we ask you to complete. It's on the right side of your screen. We would love your feedback on today's webinar, how we can improve it, and what topics to potentially address for next year. If you have any technical difficulties with the webinar, you can refresh your browser or see the webcast help guide on the bottom of your screen. Also, if you have any issues, feel free to type anything in the Q&A widget too if you're having trouble, and we'll try to address it there. We have 4 different speakers today, including myself. I'm not going to spend a lot of time introducing each speaker because you can go to our website and get their bios. I think their expertise is going to speak for themselves as they give you their presentations today. Our first presentation is going to be from one of our newer partners, Matt Krieger, who joined us from the Department of Justice. And he is going to be talking about a very important topic, which is the False Claims Act and important updates in that area. We're then going to turn to other transaction agreements, which is a joint presentation by Julia DeVito from our Washington, D.C. office and myself. And then the Buy American Act from David Ralston, a partner in our Washington, D.C. office. Bid protest back to Julia, and then regulatory updates back to me, and that is where we'll be talking about the vaccination requirements. So yes, I'm cruel. If that is why you've tuned into this program, you need to wait to the very end. So with that, I'm going to turn it over to Matt to talk to you about the False Claims Act.
Thank you, Erin, and good morning. I'm excited to talk to you about the False Claims Act, even though I imagine that if any of you have to actually deal with a False Claims Act problem, it's not not very exciting and not the thing you want to be doing. As Aaron said, I came to Foley earlier this year from the Department of Justice. I was serving as the United States Attorney for the Eastern District of Wisconsin. And before that, which meant that I was supervising our False Claims Act work, I previously was an AUSA doing False Claims Act cases, including in the procurement side. What I'm going to touch upon today are some basics, just to be sure we all recall what the False Claims Act covers, then talk about some recent enforcement activity, and also hit on case law developments in a couple areas that I think are important for you all to be watching. Then I'll be turning to what the main priorities of the Justice Department and its partner agencies are right now, before ending with some recommendations on how to prevent False Claims Act problems for your entity, or to respond if you do have a potential problem. So we're going to start with the basics of the False Claims Act. It's essentially a statute that deals with fraud against the government. Most False Claims Act suits deal with either the healthcare industry or government procurement. But it's important to realize that the scope of the False Claims Act reaches really any situation where there are federal dollars involved. This can include grants, it can include federal programs or their reimbursement. And it can mean that when, particularly as we're seeing new levels of stimulus funding that block grants, for example, to states or localities where the state or locality is administering the funds, that nonetheless can be reached by the False Claims Act. There's potential liability for any of the following: submitting or causing to be submitted false claims to the government, making a false statement, a false record that will then be used later to support a claim to the government, or concealing, avoiding an obligation to the government, which is sometimes called a reverse false claim. False Claims Act matters partly because its implications are so severe. It allows for treble damages plus statutory penalties for each claim. And the amounts of those penalties increase with inflation every year, so it's significant amounts of dollars. In addition, states and municipalities often have their own False Claims Act. We're going to briefly touch upon the main elements of a False Claims Act case. You first have to have some claim, a request for money or property that is eventually presented to the federal government, even if the defendant himself is not the one who presented the claim. It could be by a contractor, a grantee, or other recipient of federal funds. And then again, the liability can reach one who causes it. So a subcontractor on a prime contractor's claim, for example. The claim has to be false or fraudulent. And we, in this area, often distinguish between factually false claims and legally false claims. Factually false is just what the notion sounds like, that something on the claim itself is misrepresenting the actual situation, perhaps, for example, the type of product furnished. When we talk about legally false claims, we're in the world of where there may be various conditions of payment on a government contract or in a government program, and a claim is submitted even though the contractor or the participant isn't in compliance with that condition of payment. Given how complicated federal programs and federal contracts are, that this becomes an area of significant fights. And part of the question is whether the condition that may not be complied with is actually material to the government contract. Because to make a False Claims Act case, the government or a relator has to prove that the falsity or the fraudulent part of the claim was material to the government's payment decision. The knowingly aspect, the knowingly element of the False Claims Act is particularly important to be aware of because unlike criminal law, where the mens rea usually requires an actual subjective knowing of the falsity or even a specific intent to defraud the government, under the False Claims Act, which is a civil suit, only has to be proved by a preponderance of the evidence. It can be established by an objective, essentially gross negligence standard, a deliberate ignorance of the falsity of the claim or a reckless disregard for the truth or falsity of the claim. When I mentioned earlier the term relator, assume most people know about this, but it's worth flagging that under the False Claims Act, it's particularly such a big risk because it can be brought not only by by DOJ itself, but also there is a significant whistleblower provision where the whistleblowers, called relators, can file suits in the shoes of the federal government. And that's where many of these cases come from. On that score, I'm going to quickly overview the most recent full fiscal year of false claims activity that DOJ has reported on. Last year, ending for the last fiscal year 2020, and we should get fiscal year 2021 pretty soon, the federal government recovered over $2.2 billion under the False Claims Act. That number is large, but it was actually lower than the last few years. Some of it was just a timing issue. There were significant False Claims Act recoveries late last year, many against large pharmaceutical companies. And so on the calendar year, it was even closer to $3 billion. Under this pie chart, you can see where the cases where these cases come from. When I say DOJ suits, which covered about 1/4 of these, those were suits in which there was no whistleblower, no relator, but it was just DOJ opening and pursuing the case itself. But that means that 3/4 of the cases, 1.68 billion of it, involved a key tam suit where there was a whistleblower. DOJ also reported last year that it opened over 900 new matters under the False Claims Act, which was a record, more than they had ever opened in prior years. So to my mind, the takeaway is that the False Claims Act remains significant for government contractors. It remains significant for DOJ. When I was U.S. Attorney and as I worked with my colleagues, this was a priority area. It was an area where more prosecutors were being added and where the government believed there was a significant return on investment, so to speak. And again, worth noting that whistleblowers drive most of the False Claims Act cases. This slide hits upon just 3 enforcement cases from the past year. And I chose these more than anything just to show that there remains a wide variety of types of cases under the False Claims Act that touch upon government contractors. These types of cases have been happening for some years, and I imagine and I know DOJ continues to investigate them. For example, a Buy American Act case, as David will talk to us more about. In this case in particular, Southeastern Equipment settled with the government for $900,000, arising out of allegations that it had provided substitute parts that were manufactured in a non-qualifying country. It also had another violation that dealt with the U.S. Army's simplified non-standard acquisition program, where again, the issue of it providing different parts than were required under the program. The second case we called out involved a situation of misrepresented services. A case that you may have noticed if you got a lot of headlines was involving United Airlines, which settled both criminally and civilly, paying $49 million in total, and $17 million of that was through a criminal restitution, which I think highlights that DOJ often investigates these cases in parallel, both civil and criminal. The issue there was that United Airlines had agreed to do international delivery of parcels, and the payment on the contract would only be at its maximum level if the parcels were delivered on time. And United Airlines had to scan the parcels and report that data to the government to show whether the parcels were delivered on time. As it turned out, they had a program which was reporting to the government aspirational times that would have allowed for the full payment and weren't the actual parcel delivery times. One thing that I think is really interesting about this case is that it was investigated in large part through sophisticated analysis of the data itself, looking for patterns that seemed unusual, that seemed not to align with how parcel delivery would have really happened in the real world. And so I think it speaks to the increasing sophistication of DOJ to be able to use more sophisticated data analytics to interpret and investigate cases. Certainly, as in my time in DOJ, I was there for about 8 years, I saw significant improvement, so to speak, in the sophistication of DOJ and being able to analyze claims data or other empirical evidence to try to find problems. Lastly, I included an example of a small business fraud program case where a contractor represented that it was a small disadvantaged business enterprise under the SBA's 8A program, when in fact it was in a joint venture with another entity, and that other entity was actually controlling and performing the contract. We've seen just a continued number of cases under the small business program, some with, for example, disabled veteran-owned businesses and other types of SBA programs. Those will remain a focus area for DOJ. Moving on to two areas where I think it's worth watching the case law. The first are decisions that are interpreting what is the standard for showing a knowing violation. The issue here to keep an eye on is that many contractual clauses or regulations are arguably ambiguous. And if a contractor has an objectively reasonable belief that it is interpreting, that its interpretation of the requirement is a plausible one and that it is complying with it, then the question is, could the contractor have knowingly submitted a false claim if ultimately DOJ or the contracting agency or a court would say that that interpretation of the requirement was different? There have been another number of Court of Appeals cases, most recently, and one that I think is very favorable for defense counsel is the one I've listed here, Shoot versus SuperValue, which was in the Seventh Circuit, came out this summer. It was more of the healthcare area. The issue there was that pharmacies are required to charge the government the, quote, usual and customary price for prescription drugs. Question is, what was the usual and customary price? There was no authoritative guidance on this issue. There was a Medicare benefit manual that had some guidance, but nothing that was very clear. And the defendants there interpreted that clause not to require, not to include pricing where there was a local discount to match the pricing at another competing pharmacy chain. And it believed that it was reasonable to interpret that term not to include those discounts. As it turned out, federal Medicare Part D disagreed with that and said that wasn't the right interpretation. But the Court of Appeals said because this was an objectively reasonable interpretation of the regulation, the defendant could not have acted knowingly. So I think there are key takeaways for practice in this area, that whenever you hit an arguably ambiguous question about a contractual clause or a regulation, to be very clear about what it is that what is that ambiguity, and be very clear, even document to your records what is your interpretation of it and the reasons why it's objectively reasonable. And if you do that, you'll put yourself in a much better situation if it's questioned down the road for why you did not act knowingly. Another area of case law that I want to hit upon is our cases under the materiality standard. Many of you may be familiar with the Supreme Court's 2016 decision in Escobar. Really set the bar for what is materiality in situations where you have legal falsity, situations where the question is whether non-compliance with a contractual or a regulatory condition would make the claim material. And the key question that was at issue there, and there are others, but is if the government is arguably on notice about non-compliance, but continues to pay on the contract or the program, could it nonetheless be material? This is a heavily litigated area. It leads to a lot of discovery on the government to ask what did the government know about the conduct, whether the government made some decision to keep paying. And the court decisions in this area are going in many different directions. I suspect that it may eventually get up to the Supreme Court again. I pulled out one that's worth taking a look at, but I suggest that you regularly track the case law in this area. In this 11th Circuit case, the relators, the whistleblowers alleged that lenders under a VA mortgage program had falsely certified that they were not charging certain fees on the mortgages. There was evidence that the VA knew that certain lenders in the program were charging these prohibited fees, but the VA did not revoke its its payment on these loan guarantees. And more importantly, to my mind, the VA did not kick the lenders out of the program or take particular action to suspend them. That, I think, would have made a good defense argument for why these were not material conditions. But in this case, the court went the other way, a reverse summary judgment, and said that a jury could nonetheless find that the false certification about these fees was material to the VA. And it focused on the fact that the VA's regulations were clear about this being a condition of payment, and that the VA was doing audits and sending warnings in this area. So to me, the takeaway is, again, to be, if you are facing a question of whether some condition of a contract or program is material, to keep good track of what the government's statements, what the agency's statements have been in that area as you assess your risk. Particularly because of all of the litigation around materiality, there is potential legislative activity. There may be amendments to the False Claims Act. Senator Grassley has been a champion of the False Claims Act, and he has introduced the False Claims Act amendment, the False Claims Amendments Act of 2021. It was introduced with bipartisan support, and there's been some concern that it would be included in the infrastructure bill that may get passed this year. And so, although every year I think there's probably some legislative chatter about the False Claims Act, I think this one is more worth watching. It's going to actually be in the Judiciary Committee in a hearing tomorrow. So it'll be interesting to see if they move it forward. The key provisions are first to address this materiality issue, where Senator Grassley thinks that Escobar has created too much litigation in this area and too high of a burden for the government. And so it would make it more difficult to rebut, for defense counsel to rebut a showing of materiality. It would also include new provisions that allow the government more easily to recover its costs and fees for having to respond to discovery. And it would also make it harder for the government to dismiss QTAM suits. So to the extent your organizations are involved in trade associations or industry associations that weigh in on legislative activity, I think that this legislation is frankly bad for government contractors. And there are parts of it that don't make much sense. And I'd be happy to share my thoughts on that more if you're interested. But I would encourage you to watch this legislation and encourage your associations to weigh in on it. I'm going to turn now to where I think DOJ and its partner agencies are putting particular attention in the coming months and years. First and foremost is anything related to the various COVID relief bills. We've seen an enormous amount of federal dollars that have been put into the economy. Some of it directly related to mitigating the impacts of the pandemic, but some of it not so related. And in this coming year, if the infrastructure bill passes, we may see many, many more federal dollars. Although I said that I did see in my time in DOJ resources for False Claims Act work continue to be there, I'd also say that there has been nowhere near a commensurate increase in enforcement resources as there has been in increased spending. If you think about the increase in spending, you don't have anywhere near the number of new agents or prosecutors. So part of how I think the government is dealing with this is that it's creating specialized units and task forces to try to focus especially on COVID-related issues. The Attorney General has a task force. There's a Special Inspector General for Pandemic Relief, as well as an Accountability Committee. And then within each different part of DOJ, each U.S. Attorney's Office, there are essentially little mini strike forces focused especially on COVID-related fraud. And so I think for present purposes, this means a couple things. One, that if you do have any contracts that are directly related to the pandemic, perhaps related to PPE or testing, that's going to be a focus area for the government. And then another area will be where there was inappropriate spending or receipt of relief funds. One example are problems of what we call double dipping. For example, if you have a time and materials contract for which you're submitting reimbursement for labor, but that same labor was also covered by PPP loans. The government would say you can't be paid twice for both expenses. And I know different agencies are working to match data to watch for situations of double dipping. Taking a step back, because this is such a priority area, the leaders of different parts of the agencies and U.S. attorneys' offices feel pressure to demonstrate that the spending is being used wisely, that there's accountability for those who misuse the COVID relief spending. So I think that means if you find yourselves dealing with a problem like that, it's probably going to be harder to convince the government to resolve it more easily or to walk away from it. It's going to be a focus area. Another area that I think is worth significant attention in the coming years, this is probably going to have a longer timeline, are cybersecurity issues. With increase in ransomware, with increased attention on vulnerability of government systems, this will be a focus for, I think, really all government agencies. We've even seen the Department of Labor and other agencies say that they're going to focus on this. And so, for example, late last year, DoD put out its regulations requiring prime contractors and subcontractors to complete a NIST SB 800-171 assessment before it could receive new contracts or exercise new options on existing contracts. And then, as we know, the CMMC will be rolled out over the next few years. Likewise, this year, President Biden issued an executive order where he initiated rulemaking for IT and OT contracts to have to hit certain cybersecurity standards. So under a False Claims Act perspective, I think the question is whether false certifications of compliance with cybersecurity requirements could amount to false claims and create False Claims Act liability. There is some precedent for this. If we look at cases over the past few years, I don't think it's an area that's well developed yet, but the leaders of DOJ have articulated this as a focus area. So particularly if you're in the situation of providing technology to the government, or if you handle very sensitive data for the government, for example, DoD contracts, this is an area that is worth significant attention. Another priority area is procurement collusion. Under the last administration, there was created a procurement collusion strike force, which was a joint effort between DOJ and other partner agencies out of concern that there had been situations like bid rigging on government contracts. With the new administration, I think it's clear that this focus will continue because antitrust issues are such an area of focus for the current administration. We see that with the FTC and with DOJ. And so the Procurement Collusion Strike Force has continued to receive significant resources. One of my prosecutors, for example, from the Eastern District of Wisconsin, moved on and was hired by antitrust to join the Procurement Collusion Strike Force. This can result in enforcement in a couple of different ways. This can be a matter of criminal issues. The Antitrust Division brings criminal cases, but it can also sound under the False Claims Act. For example, in June of 2021, a Belgian security services company was indicted criminally for bid rigging related to defense-related security services on military bases. But earlier, more under a civil perspective, Hybrid Tech Holdings and Ace Strength International paid $29 million to resolve allegations that had violated the False Claims Act on bid rigging for loans under DOE. This is another area where DOJ is working to try to have, to use data to look for problems. For example, they're working to look for situations where a company that usually bid on certain types of contracts did not bid on one, but had received some significant subcontract as an area of potential collusion. So it's worth significant training and monitoring in this area. Moving to that perspective of prevention, I've got a couple of slides on practical tips for what you might do today to avoid False Claims Act risk. First and foremost is to put the needed resources to your compliance program. Strong compliance programs can go a long way, along with comprehensive training for your employees to mitigate False Claims Act risk. If you're not familiar with it, I'd strongly recommend looking at DOJ's updated guidance from June of last year on the evaluation of corporate compliance programs. It's very general across industries, and it asks basic questions that will give you a sense of how DOJ thinks about what's an effective compliance program. Part of that involves risk assessment. We all do risk assessment all the time, and I think the question to ask is, of your limited compliance resources, where is the biggest risk, and how to determine that? I would submit, for example, you want to be asking which personnel interface with government officials, which of your personnel interface with other competing companies that might be tempted to be sharing cost information. Which of your projects are under the tightest timeline or have the tightest profit margins, where your employees will be facing the most pressure to try to move quickly or to cut corners? Those are the areas where you want to put most attention. My third practical tip would be to ask, how does your organization prevent a qui tam suit from being filed? How do you respond to tips to your compliance hotline? How do you interact with potential whistleblowers so that they have a sense that their concerns are being addressed, but that you also don't overshare so that they end up being in a situation where they know so much that they could file a whistleblower suit? So I think it's really critical to train your managers, your frontline managers, to take seriously problems that employees raise so that they don't feel like the problems are being ignored. And a lot of times in my experience, whistleblowers came forward because they felt like their organizations weren't taking them seriously. I would then ask yourself, if you're not in a prevention mode, but if you are in a situation where the government is looking at you, whether you're prepared and what are your practical steps to respond to government inquiries. Do you have corporate policies for dealing with government inquiries? To make this very practical, before we would ever charge a case or file a suit, we would try to take the opportunity to have one of our agents, for example, an NCIS agent, go and just knock on the door of the target company and see if we could have that person be caught, frankly, by surprise with their guard down a little bit and see what they would say about the situation. And so are your employees prepared for that? If they get a knock on the door as they're going to work in the morning, do they know their rights? That they, for example, don't have to talk to an agent. They don't have to do an interview, but also their obligations that they must speak honestly. Far too often, what would come out of that sort of encounter was that the employee would lie because they were scared. Maybe there wasn't even that much significant going on at the company, but the pressure of that situation would lead them to feel like they had done something wrong and to give false information, and then they've made the problem much, much worse. We have checklists and suggested policies on how you'd want to train your employees. I'd be happy to share those with you if that's of interest. But I think you want your employees trained on how to deal with inquiries for, sort of requests for interviews, also for responding to subpoenas or records. Although search warrants are relatively rare, you do want to have your employees trained and prepared for what to do if the government would actually come knocking on your organization. And also clear policies on how, when to conduct internal investigations to be able to get ahead of what the government might be looking at. If you do think that you have a problem that might arise to False Claims Act liability, to be proactive in doing an investigation, understanding where the concerns might be, and take proactive steps to engage DOJ. Because you will receive cooperation credit and find yourself probably in a better overall resolution. But my last bullet, and I really do believe this coming from having served in DOJ, an organization that I feel great affection for, that it is not infallible, that there are situations where the government is just wrong or is overreaching. And so it's important and it's appropriate to assert your rights to, for example, show where your view of a regulation is objectively reasonable and that the government is wrong in its view, or at least that you could not have been acting knowingly because your view of the situation was reasonable, or where the government just doesn't really understand the facts properly and that there's a need to push back and clarify the situation. And so it's again, it's something where I feel very strongly that we shouldn't have a posture that whenever the government comes knocking, that all we need to do is sort of roll over and say the government must be right. With that, Aaron, I would be pleased to cede my time to my esteemed colleagues. I really appreciate the opportunity to chat with you all this morning, and I want to say thanks to Aaron for helping organize it all.
Thank you, Matt. That was fantastic. And it's important to keep in mind, too, and this dovetails what Matt was saying about internal investigations, that under the FAR, there's a mandatory disclosure requirement if you have a contract over $6 million that contains FAR 52203-13, the Contractor Code of Business Ethics and Conduct. But also, it could be a basis for suspension debarment if you have credible evidence of a violation of the Civil False Claims Act and you do not make a mandatory disclosure. So in connection with those internal investigations, pairing them with disclosures, and what I tell clients is that helps you to create the narrative. Rather than the government thinking the worst and running away with it, it helps you to put out, this is actually what happened. I know this might look bad, but this was done inadvertently, and here's why. And I find that the government does respond favorably. I always say it's like with my children. If they do something wrong and deny it, I have no faith that they're not going to do it again. But if they come to me and they apologize and they tell me they're not going to do it again and why they won't do it again, then I have faith that they won't do it again. The government is the same. It's our parent. They want honesty from their contractors. So the next topic we're going to move to is the rise in the government's use of other transaction agreement authority. Julie and I have been very busy over the last few years in reviewing, revising, negotiating, doing flow downs for OTAs, other transaction agreements. And so we have seen the rise in it in our practice, and we thought it would be timely to discuss it so that companies can be aware of it when they either see an OTA or a subcontractor under an OTA, as well as actively seek out OTAs from the government. So Julia, take it away.
Thanks, Erin. So first, we'll just talk about when we're talking about OTAs, what are we talking about? And that is other transaction authority that some government agencies have granted to them by statute the authority to issue into what are called other transactions, essentially transactions that are not procurement contracts, they're not cooperative agreements, and they're not grants. They're other than that. And they're typically used to provide funding to support research and development activities. OT agreements, other transaction agreements, are referred to as OTAs, and that's what we'll call them today. As I mentioned, OT authority is granted by statute, meaning that if an agency doesn't have statute authority to issue an OTA, they can't do it. OTAs typically are used for research and development that has both a public and a private benefit. The government has been issuing OTAs for decades, but there is, as Erin mentioned, we're seeing more of a rise in the use of them, particularly by defense agencies. So that's why we wanted to talk about it today. There are a number of agencies that can issue OTAs. On this slide, we have a chart that shows the different agencies that have other transaction authority. Department of Defense is one of them, but also Department of Energy, Health and Human Services, Transportation, and other agencies. And as you'll see on this chart, we have two columns, one for research authority and one for prototype authority. And that's because the statutes that authorize agencies to issue OTAs sometimes vary in what type of OTA the agency can issue. So all of the agencies can issue research OTAs, and only some of them can issue prototype OTAs. And I'll talk about those in detail in a minute. OTAs are beneficial for a number of reasons. One of the main reasons is that they can help get involvement of non-traditional defense contractors in addition to traditional defense contractors or traditional government contractors. And that's because OTAs often have a more streamlined and flexible process for bidding on or submitting proposals for an OTA, and also the obligations and compliance requirements for OTAs are often less onerous than those involved in procurement contracts and grants and cooperative agreements. So those features tend to attract the non-traditional defense or government contractors who would not otherwise be wanting to get funding from the government and be subject to those more onerous requirements. And because of that and the increase in the government's ability to work with commercial industry entities, the government can leverage industry investment in technology by adding some government funds to make more investments and developments that can benefit both the government and as well as the private sector. So that has those types of projects have a dual use, the public and the private benefit. As I alluded to earlier, there are multiple types of OTAs. There's really two larger types, and then the second type has a subset that we'll talk about. So the first main type are the research or R&D OTAs. Those are OTAs that support research and development work that could have some sort of benefit for the government. The second broader type are prototype OTAs, where the government is funding the development of an actual prototype, which might be a physical, a virtual, or conceptual creation, just something that would be beneficial to the government. And then a subset type of prototype OTA is one where the government actually funds the production of the prototype that was developed under a prototype OTA. So that is called a production OTA. The Department of Defense is authorized by their OTA statutes to issue all three types of OTAs. And we're going to be talking today mostly about DoD OTAs because those are the types that we see most often, as well as DoD has issued a lot of guidance on how they issue their OTAs, and that is really helpful for contractors to be able to get a sense of how DoD will approach the OTA process. So first I'll talk about research OTAs and how DoD can enter into them. DoD can use research OTAs to carry out basic, applied, and advanced research projects. And OTAs are particularly beneficial for dual use research that can be of use to the public sector, of use to the government, and also for the private sector. Research OTAs can only be used if the government couldn't use a procurement contract, a grant, or a cooperative agreement for that type of work. If it wasn't feasible or appropriate to use a procurement contract or grant, then the government could use an OTA. So it's sort of not exactly that the OTA is an instrument of last resort, but more that if the government can issue a contract or a grant or a cooperative agreement, then they can't issue an OTA. Generally, research OTAs shouldn't duplicate research that's already being conducted by DoD, and generally DoD will award research OTAs competitively, at least to the maximum extent practicable. So that might mean that, similar to in the procurement contract context, you might see a solicitation or a request for proposals for an OTA, and then a DoD agency would evaluate those proposals and decide which entity to award the OTA to. Also, research OTAs typically may require the participants, the non-federal parties to the OTA, to provide a cost share where part of the cost to perform the OTA would be provided by non-government sources. So the participant or its subcontractors would have to self-fund some of the work, and sometimes that would even be up to 50% of the research OTA would be a cost share provided by non-federal funding. Turning now to prototype OTAs in the DoD context, DoD can issue OTAs to carry out prototype projects that are either going to enhance the mission effectiveness of military personnel or their supporting platforms, systems, components, etc., or to improve already existing DoD platform systems or components. So essentially, DoD is seeking to make some sort of improvement that will have a government benefit, and the ultimate goal for a prototype OTA is the development and testing of a prototype. To issue a prototype OTA, DoD must satisfy one of the following requirements, and some of these are depending on the participants to the OTA. So there, in one criteria, you need at least one non-traditional defense contractor or a nonprofit research institution to participate in a significant extent in the project. Under another criterion, you need significant participation from small businesses or non-traditional defense contractors. If those criteria aren't met, DoD could still issue a prototype OTA if at least 1/3 of the total cost of the project is paid by non-federal funds. And then if none of those criteria are met, DoD still could issue a prototype OTA if the senior procurement executive for the agency determines that there are exceptional circumstances that justify it. So there still is a sort of a catch-all way to approve a prototype OTA if none of the traditional criteria are met. Like research OTAs, prototype OTAs generally are supposed to be awarded competitively. So again, there would be some sort of proposal process and evaluation for awarding the prototype OTA. And the prototype OTA also might include language in the agreement that would provide for a follow-on contract to the participants of the prototype transaction. Essentially, if the prototype is successfully developed, then DoD could award a production contract or OTA to that same entity or someone else who is involved in the prototype OTA to actually manufacture or develop the prototype. So that leads me into production OTAs. So DoD can award a follow-on production OTA for the actual production of the prototype without using competition if 3 criteria are met. First, the prototype OTA needed to be awarded competitively. Second, the prototype OTA needed to have been successfully completed, meaning that there actually was a prototype developed and it met whatever criteria was included in the OTA to determine that it was successful. And the prototype OTA needs to explicitly state in the agreement that DoD might award a follow-on production OTA, because without that language, they are not authorized to issue the follow-on production OTA without competition. There are some unique rules also about when you can award a follow-on production OTA if the prototype OTA was performed by a consortium, and to determine whether any members of the consortium successfully completed the prototype OTA. I won't go into detail about that, but there are some unique rules about that. All right, so I've touched on a little bit that OTAs are a good way to involve non-traditional contractors in getting some sort of government funding for this OTA work. And so OTAs can be awarded to traditional government contractors where the OTA is awarded to one entity and that entity self-performs the work, or that entity issues into subcontracts, or maybe forms a joint venture with another contractor and they collectively perform the work, similar to what you would see in the procurement context. But OTAs can also be issued to non-traditional government contractors. And in the DoD context, that's defined as a contractor that in the last year hasn't had a DoD contract or subcontract that required full compliance with the cost accounting standards. So there is a specific definition for non-traditional contractors. And then also OTAs often can be awarded to consortiums. And those are groups of entities that come together to perform these research type contracts or OTAs, and they're a little bit different than a teaming relationship. Sometimes there's one entity that is the point of contact for the government, and then sometimes they all work collectively together and each maybe perform a contract or a project that's awarded to the consortium. And since OTAs can often be awarded competitively, the entities that are pursuing OTAs naturally would want a forum and to be able to challenge the terms of the solicitation for an OTA or challenge the evaluation or award of proposals for an OTA, similar to what you would want to do in the context of a procurement contract and be able to file a bid protest. So the rules that apply to protesting OTAs are a little bit different than for procurement contracts, so I'll talk about those briefly. The U.S. Government Accountability Office, which traditionally hears bid protests in the procurement contract context, can hear OTA protests in limited circumstances. One of those circumstances is if you're protesting that an agency is improperly using an OTA to procure goods and services. That would be if the government should be issuing a procurement contract for the specific requirement at issue, but they issued an OTA or they're planning to issue an OTA instead. That could be a basis for protesting at GAO. Along the same lines, if the government is issuing an OTA or issues an OTA solicitation, and that doesn't comply with the applicable OTA authority that the agency is authorized to do by statute, that also could be a basis for protest. An example of that is if an agency issues a production OTA when the preceding prototype OTA didn't have the right language in it that would authorize the agency to do that without competition. That could be something that GAO could hear. But otherwise, a protest of the evaluation of proposals for an OTA or the failure to award an OTA to your company or the award of an OTA to a different company, that's something that GAO cannot hear. Along the same lines, the U.S. Court of Federal Claims, which can hear bid protests in the procurement context, has yet to say that they have jurisdiction to hear a bid protest of the award or failure to award an OTA. So all of the OTA-related bid protests that have been brought to the Court of Federal Claims have been dismissed for lack of jurisdiction. Federal district courts could be another venue for protesting an OTA. There was one case in which a federal district court did find that it had jurisdiction to hear a bid protest in an OTA context, and that was specifically because in that case, the Court of Federal Claims had previously held that they lacked jurisdiction, and so the federal district court determined that it had jurisdiction to hear that protest. So it reviewed the award decision of an OTA. But in other contexts, if the federal district court thinks that the Court of Federal Claims might have jurisdiction if the OTA was considered to be in connection with a procurement, then the federal district court likely would not be able to exercise jurisdiction and hear that bid protest. And then lastly, some OTA solicitations might provide for agency-level protests to be filed directly with the agency for that specific OTA. And if that's the case, then a bidder for that type of OTA could utilize that process. But otherwise, if the solicitation doesn't provide for it, there generally is not an agency-level bid protest process for OTAs. All right, now I'll turn it over to Erin to talk about the differences between OTAs and procurement contracts.
Great, thanks, Julia. So Julia told us about the different types of OTAs, and then the question comes, well, why would I pursue an OTA instead of a FAR-based research and development contract or a cooperative agreement or grant? Why an OTA? Well, this is why, because when it comes to the differences between OTAs and procurement contracts, OTAs are not subject to the FAR. They're not subject to the FAR supplements. There are various laws that they're not subject to, including the Truthful Cost or Pricing Data Statute, Competition and Contracting Act, meaning you don't have to comply, the government doesn't have to comply with the traditional rigorous competition that applies to procurement contracts, cost accounting standards, something that many government contractors avoid like the plague. The FAR cost principles don't apply. So what costs are allowable or unallowable under the OTA are set by the OTA, not necessarily by the FAR cost principles. The Contract Disputes Act doesn't apply. Most importantly, it is the only government-funded agreement where the Bayh-Dole Act does not apply. The Bayh-Dole Act governs inventions that are conceived or first actually reduced to practice under a government-funded agreement, and provides that the standard is typically the contractor will receive title in the invention and the government receives a broad license to utilize the invention. Under the Department of Energy rules, it's actually default if you're a large business to the government having title unless you petition for an advance waiver to have title. But that being said, that is something that for research and development purposes really makes contractors nervous because there's strict time reporting requirements for reporting subject inventions, and a failure to comply with those strict reporting requirements could result in the contractor not only losing title, but also losing a license to utilize the invention. So having OTAs being exempt from the Bayh-Dole Act is huge. And then various labor laws, the various affirmative action program, and those other requirements as well. So what's the difference between an OTA and a cooperative agreement and grant? OTAs are not subject to the uniform guidance in 2 CFR 200. So they don't need to comply with what the provisions that govern cooperative agreements and grants. Similarly, again, Bayh-Dole Act doesn't apply, as well as various non-discrimination statutes. Focusing again on the Department of Defense OTA terms, because as Julia said, that is where we see the majority of OTAs. What terms are required by statute? Well, Julia mentioned that there are some circumstances, limited circumstances, where the government can agree in a prototype OTA to have circumstances under which there would be a non-competitive follow-on production OTA. So it's important, if there is that provision in the OTA, that you need to specify the conditions under which the agreement would be considered successfully completed and allow the government to proceed in awarding the follow-on non-competitive production OTA. Also, if you have a prototype OTA with a value over $5 million, it must include a clause that allows the Comptroller General to audit the records of any party to the agreement, including all subcontractors on the agreement. It's anyone who participates in the performance of the agreement, and those audit rights apply for up to 3 years after final payment. It is not surprising that the government wants to have some level of oversight over the millions of dollars that flow through OTAs. The key provisions, though, to consider in an OTA are the intellectual property provisions. As I just mentioned, the Bayh-Dole Act is not mandatory. The FAR and DFAR provisions governing data and computer software, as well as any of the provisions in the Uniform Guidance governing technical data, computer software, they don't apply to OTAs automatically. So it's important that the parties think through the data rights, software rights, invention rights that are going to exist as between the contractor and the government. I will tell you from experience that the government defaults to the Bayh-Dole Act and the FAR clauses and the DFAR clauses because it's familiar, it's what they're used to, and frankly, it works. There's a scheme for it. There's not always a reason to object to that. If it is something where you would be okay with some of those requirements, you can tweak them around the edges, or maybe you have a lot of other government-funded research and development contracts, and you have in place standard policies, procedures that govern your compliance, and it's easy just to have the same rules across the board, that's fine. You can accept those requirements. It's just important, though, to realize that you do have flexibility as a contractor, and these are all negotiable. But make sure you address what are the contractor's rights to retain ownership in any IP developed by the contractor under the OTA, and what license rights, if any, the government receives in that IP. Keeping in mind the government is not going to fund millions of dollars and to walk away with probably no intellectual property rights. But maybe instead of getting unlimited rights license, you can negotiate it down to something more akin to a government purpose rights license. And maybe be more flexible in the period of time where the data has government purpose rights license and doesn't convert to an unlimited rights license. Also, you want to identify, does the contractor get any rights in IP that's developed by the government under the OTA if there's going to be some joint development work? If there's mixed funding and a cost share, how does that work? Typically under government funded agreements, if there's mixed funding and there's a cost share component, it's really all treated the same under the agreement, but that doesn't necessarily have to be the case under the OTA. You can have some flexibility. Also, you want to specifically identify what license, if any, the government receives in any pre-existing IP that the contractor uses to perform the OTA, or that will be delivered to the government under the OTA. And what reporting obligations does a contractor have with respect to any inventions or other intellectual property that's developed under the OTA by the contractor? Again, the Bayh-Dole Act timeframes do not automatically apply. When it comes to physical property considerations, the Department of Defense is only required under OTAs to take title to physical property that's delivered to the government as a deliverable under the agreement. So it's important to identify what are those deliverables and know, okay, the government will have title in those deliverables. Well, what else will the government obtain title to under the agreement? What if you use the funding under the agreement to buy various equipment or tooling or other materials? Who is going to own that? That is negotiable. And who gets to retain title to that at the end of it? So want to make sure that the OTA addresses who's going to have title and what equipment and supplies and material and property that's acquired under the OTA. Also, if the government is going to furnish any government property under the OTA, you'll want to identify what that is, and as well as who's responsible for the proper maintenance of the property, who's responsible for insuring it, what happens if it's damaged or lost or there's theft, who is responsible for that, and who is going to replace it or make their insurance claim on it. So those are all things that are not automatic that you'll want to think through and address in the OTA. Importantly, though, you are not subject to the FAR government property clause, and so some of the rigorous requirements of DCMA will not apply to OTAs automatically. If the Department of Defense is going to take title to property acquired under the OTA, or if they're going to give you any government furnished property, while the government property FAR clause doesn't apply, there are some provisions in there where you're going to want to similarly address in the OTA what is the contractor's requirements for accounting for, controlling of, and disposing of that property. What kind of representations and warranties is the government making with respect to government furnished property? Are they representing at a minimum that it's suitable for the intended purpose? And what happens if the government gives you government furnished property that doesn't meet those requirements? Also, if, again, at the end of the OTA, what is going to happen with respect to the disposition of property? For example, under cooperative agreements and grants, if there's a cost share portion and the contractor wants to keep the property at the end of the agreement, let's say an expensive piece of equipment, the contractor doesn't automatically get to keep that free and clear. They may have to give the government a payment for that property equivalent to the government's cost share percentage and the current fair market value. That's not the default for OTAs. That is, again, negotiable. Also, if a contractor is contributing any equipment or property as cost share, the OTA should address what is the mechanism for determining what the value is of that property for the cost share. When it comes to payments, it's not a set, it has to be fixed price, cost reimbursement. It could be either. We often see fixed price OTAs based on various payment milestones. There is the possibility to ask for advance payments if you have a large upfront expenditure, or you can have interim reimbursements based on some version of costs incurred, again, not necessarily subject to the cost allowability principles in the FAR. With respect to payments, the government may seek to include in the OTA a provision that allows them to recoup any government investment. So what happens if the contractor just stops doing the work under the OTA and they've received a bunch of money, but the government really gets nothing for it? The government could have a provision in there that allows them to recoup those payments. The government can also impose some requirements on the contractor's accounting system, but what's key is that the Department of Defense discourages requirements that require a contractor to alter their existing accounting system. Again, the purpose of these OTAs is to get contractors involved who are not traditional defense contractors and to allow some commercial companies to utilize federal funding to develop innovative prototypes and other technologies. The OTA should also include provisions on changes, disputes, and termination. So our modifications, how are they done? Do they always have to be mutually agreed upon? It's not automatic that the government has the right to unilaterally issue modifications like they do under the FAR. Since the Contract Disputes Act doesn't apply, you want to make sure the OTA does have some procedure for disputes. Often it involves discussions and various escalations throughout the organizations if you can't resolve it at a lower level. And then also should have termination provisions. OTAs can allow both parties to terminate the agreement. So if you want to have the right to terminate if things are going sideways or request termination, you can seek to include that in the OTA. There might be limitation on either party's rights to terminate the OTA. The government doesn't automatically have the same termination for convenience rights that are in the FAR, but we do find that if the government includes a provision along the lines of if the government finds that the results are not commensurate with their expenditure of resources or the investment, then the government may decide to terminate, and then you'll have to address, well, what happens in the event of termination? What payments are made to the contractor? How is the property disposed of? So on and so forth. So Julia mentioned that there's increased use of OTAs in recent years, and here are just some statistics to show that. So we can see in fiscal year 2013 on Department of Defense, there was a report of 12 prototype OTAs that increased to 94 by 2017. And then we saw in a GAO report in November of 2019 that from fiscal year 2016 to 2018, the number of prototype OTAs and modifications increased from 248 to 618. And the obligations on these OTAs increased from $1.4 billion to $3.7 billion. So this is a continued area of growth, and we recommend that you keep your eye on OTAs and consider pursuing them if you want to receive some federal fundings for research and development and want some more flexibilities in the terms and conditions. That's going to bring us right now to our first poll question, where you will need to enter in the CLE code if you want CLE credit for attending. So I will give you the code. It is J as in Jaguar, K as in Kangaroo, X as in X-ray, 9, and A as in Apple. So type that into the box. It is J as in Jaguar, K as in Kite, X as in X-ray, the number 9, and A as in Apple. Last time, JKX9A. And next up, we have David Ralston, who's going to talk to you today about the Buy American Act and recent updates. We find that clients continuously have questions about Buy American Act, its application. It's complicated, it's confusing, and it's only gotten worse with the new requirements. So David, take it away.
Thank you, Erin. The Buy American Act and the Buy America statutory requirements have received more focus in the Trump administration and now in the Biden administration and in Congress in the infrastructure bill than perhaps in more than a decade. And with the looming changes on the horizon and considerable expansion, we thought it'd be helpful to give you background on that as well as what to expect so you perhaps can take steps in advance to begin to address them. We first point out that the Buy American Act and the Buy America statutory requirements are two very separate regimes. Buy American Act applies to direct procurement by the United States, such as an Army construction project or purchase of products. By contrast, Buy America applies to federal financial assistance, principally through the Department of Transportation, and it's flowed down to contractors through the grant assurances with states and localities, and then that's put into their procurement contracts. There are other domestic source requirements. We mentioned them there. We're not discussing those today. Next slide, please. The Buy American landscape is complex and, as I'm going to brief you on, subject to considerable change. It's complicated because of the multiple regimes that vary from agency to agency, the type of product, type of contract, and would underscore that no really answer fits all, because there is such a difference in these regimes. It really requires someone who has been trained in the area to answer the technical aspects of it. And subject to change. There was a Trump administration regulation issue, as I'll discuss, the very last day of the administration. And the Biden administration has issued an executive order that creates a new Made in America office and is now undertaking a comprehensive re-examination of the existing rules designed to, in essence, better promote domestic manufacturing and jobs. Next slide, please. The Biden Made in All of America executive order and the new infrastructure bill, as I've mentioned, anticipate substantial rulemaking changes. This new Made in America office will, for the first time, in essence, have a federal agency that may take opposing positions on waiver requests by private industry. And they're now undertaking a considerable effort to review longstanding positions, interpretations, and waiver positions in the Made America rules. The outcome will almost certainly be that non-availability waivers will be very difficult to obtain going forward. And the infrastructure bill that the Senate passed in August will impact both Buy American Act and Buy America requirements, with now potentially uniform made in U.S. definitions and a new uniform process and standards for waivers. And of particular note is a likely dramatic expansion of the Buy America requirements as now are implemented by the Federal Highway Administration. And I will discuss those in a bit. Next slide, please. We'll turn first to the Buy American Act. I would give you 3 overall points as we're going through this. Again, this whole landscape is changing. Second, it's complicated with these multiple regimes. So keep that in mind as I go through this. And if there are new regulations and statutes, there'll be, in essence, a transition to yet another regime that'll be overlapping between the pre-2021 and the post-2021. And I think what you'll see here is that the Buy American Act changes are likely to be changing of current rules designed to favor domestic manufacturing, whereas in the Buy America area, you're going to see, to some extent, more uniformity, but more robust rules at agencies that have not been as aggressive in terms of enforcement or implementation of the Buy America requirements by virtue of using waivers. The Buy American Act, which created in 1933 by Congress, creates a domestic content preference. Again, it governs only U.S. government procurements when the U.S. government is a contracting entity. And it operates through a price disadvantage on foreign goods. And there has been a recent change to this. The Trump administration recently defined foreign steel content limitations, and we'll talk about in a minute how that impacts, of limiting it to 5%, no more than 5%. So if it's more than 5% foreign steel in the product, it becomes a foreign steel product. Next slide, please. The statute is implemented through contract clauses that require the bidders to certify, in essence, the status of their products, whether it's foreign or domestic. The foreign offer effectively has to be significantly lower priced than the domestic offer to be eligible for award by virtue of that price disadvantage. What the contracting officer does is add a certain price evaluation factor to the foreign offer, and if the domestic offer is lower priced than this adjusted foreign offer, obviously the award will go to the domestic offer on the basis that it is less expensive. In short, a quick illustration, if the foreign offer was for a widget at $20 per widget and the domestic offer were at $23 per widget, on a straight analysis, obviously the domestic offer would fail because it would be $3 more expensive than the foreign offer. But as we'll see in a moment, at DoD, for example, there's a 50% add-on, so the foreign offer would be priced for price evaluation purposes at $30, and in that case, the domestic offer would prevail because $23 is less than the $30. There is, by contrast, no restriction on the products that can be offered. They just face, from foreign countries, the price disadvantage. So, for example, in theory, a Chinese product can be offered. Consistent with the Buy American Act, it would simply face the price disadvantage. Next slide. The Buy American Act applies to end products and construction materials. An end product essentially is a contract line item in government contract language. It's the item of supply. Construction materials are somewhat different because, in a sense, the contract line item in a construction project for a federal agency is the building or the project that's being built. So think of the construction materials as effectively the component of the building. And as I lay out there the definition for you, and again, it can vary depending upon how the item arrives at the job site. So for example, you could have a generator and a transfer switch may be treated as two separate items, even though often used together. And each of them have to independently meet the BAA test for domestic construction materials. Next slide. I mentioned the price preference. It depends on which agency is acquiring it and the status of the offeror. At the Department of Defense, it's a 50% add-on. For non-DoD procurements at civilian agencies, it's a 20% add-on for a foreign offer if the lowest price is from a large business. If the lowest price is from the domestic small business, then it's a 30% add-on. So, and obviously an advantage for small business. The binding executive order I mentioned earlier requires the federal rulemakers to consider increasing these price evaluation factors to provide yet even more advantages to domestic offers. So you could envision the 20 and 30% moving closer to the 50. Next slide. The test for whether a product is domestic depends on the type of product. And I would characterize these really as three separate product areas. First is a commercial off-the-shelf item, certainly a concept well familiar in federal procurement. The second is a non-KITES item, really every other kind of item but for that. And the third is those that are predominantly iron or steel. Now, if you think of the commercial off-the-shelf item, it only has essentially a one-factor test. The second is non-COTS items, which have two, both the made in the U.S. and the component test, and then the predominantly iron or steel materials have a two-step requirement. Next slide. When predominantly iron and steel for that kind of product, it means that the cost of iron or steel content in the item exceeds 50% of the total cost of all components. And to be domestic, the predominantly iron or steel item has to be manufactured in the U.S., have no more than 5% foreign content, and it has to meet the components test. Next slide. What is foreign steel for purposes of BAA content? Essentially any iron or steel product not produced in the United States. That's the default position. Produced in the U.S. for purposes of this test is very demanding, as it requires that all manufacturing processes of the iron and steel take place in the United States from initial melting stage through the application of the coatings, which requires a tracing process back to the melt stage to ensure that all production has been domestic. Iron or steel of unknown origin, other than COTS fasteners, must be treated as foreign. So if you don't know, the outcome is it's a foreign steel product. Next slide. For non-KITES items, this is that second step of the test, that component test I mentioned, and for steel, there are two types of components, purchased versus manufactured. The cost of a purchase component is the acquisition cost paid to acquire it. And I lay out some of the factors there for you in terms of that. Whereas the cost of a manufactured end product from its components are not included in that calculus of the components calculation. It's purely an inputs calculation. So again, purchased versus manufactured, two different types of components, separate tests. Next slide. There are several waivers or exceptions to the Buy American Act, and these in many ways shape the landscape because, as you'll see as I go through particularly the Trade Agreements Act, the waivers serve to cabin the practical application of the Buy America Act to relatively a small segment of federal procurement. The first you have is the unreasonable cost analysis, and I just went through that. That's what those price preferences get at. And so if a U.S. product can't, in essence, be more price favorable with the application of the price advantage to the foreign product, it's considered to be an unreasonable U.S. cost product. Second is domestic unavailability, which is when there simply is no U.S. manufacturer. And these are the kind of waivers we think are going to have increasing difficulty in being approved. The Trade Agreements Act, that I'll cover at length in a minute, essentially affords equal treatment to offers from products overseas and essentially does not apply the price preference test. And then materials for use overseas, which also may end up having some limitations under the Biden administration review. Next slide. Looking forward, the Senate-passed infrastructure bill would have a uniform produced in U.S. definition and uniform waiver standards and a process. It recommends an increase for that second step component test that I mentioned from 55 to 75%. A Biden administration executive orders could result in further changes. I mentioned those there, and the next slide will give you a little bit of sense of what those are. First, it directs a review of the current BAA clauses to consider whether the changes have to be made to, in essence, adopt a new test from a cost of components to this value-added concept. Not clear today what that will really mean. Another review of the waivers, and again, to some extent, all of this may be lapped by the infrastructure bill if it's adopted. But even in the absence of it happening, that process is underway within the administration. Next slide. There's also an executive order on America's supply chains, which is separate really from the Buy American Act review. This reflects apparently a growing concern about dependency on foreign sources, particularly China, for critical goods, products, and services. It directed a study and report on supply chains in 4 sectors that include semiconductor manufacturing and high-capacity batteries. Next slide. There was a report issued in June, and you have there the recommendations that critical products list be established and that the Department of Energy strengthen domestic manufacturing requirements under grants, cooperative agreements, and R&D contracts. Again, this is separate from the Buy American Act, although it would be, in essence, working in tandem with. So we'll now turn to the Trade Agreements Act. And as I mentioned a moment ago, that is, in essence, a waiver, an exception, a carve-out from BAA. Next slide. It waives the BAA for end products from designated countries, and I provide the list there for you. The most frequently known is the WTO GPA. Those are listed in the FAR, as are all of the other countries there. Next slide. There are some notable countries who are not WTO GPA signatories: China, India, Brazil, Thailand, Malaysia, and the Philippines. And the impact of the Trade Agreements Act is that the United States cannot buy end products from those countries or other signatory countries when the Trade Agreements Act clauses are in the contract. The TAA mandates that the United States buy either U.S. government products, purchase U.S. products or designated country products. It prohibits the acquisition of products from countries such as China, India, or Brazil. Now, draw that in contrast with the Buy American Act. There's no price add-on construct in this approach. It's an absolute prohibition. But once the product is determined to be a designated country end product, then it faces no price differential in competition with the U.S. product. So essentially, it's if you get in the door, you're on the level playing field with respect to the domestic product. Next slide. Now, you'll see from these thresholds that the TAA applies to federal government contracts at a relatively low level for supply and services contracts, $182,000 and above, and in some cases lower thresholds under some trade agreements. Construction contracts, $7 million. And I give you the citation of where they're listed. So, and in short, the BAA applies below those thresholds or other carved out areas I'll mention in a minute, and the Trade Agreements Act applies at the thresholds above. So you can see from that other than for the two things I'll mention here in a moment, DOD and small business, the application of the Buy American regime is fairly limited given the Trade Agreements Act, which is applicable to essentially all contracts other than what I will explain to you here. So the tinkering, so to speak, that the administration is going through is only going to have an impact really in those areas because the Trade Agreements Act essentially reflects international agreements the United States has entered into, and the ability to change those is limited. Indeed, the Senate Infrastructure Bill expressly says that its rules that are in that bill would be junior to the Trade Agreements Act requirements. So they're not trying to upset international agreements. The TAA does not apply to department, it has limited application to Department of Defense procurements, more limited. In short, the way it works at the DOD is that the Buy America clause that's used at DOD effectively combines the Buy American Act along with the various Defense Memorandum of Understanding agreements that are in essence incorporated into one clause. So the Department of Defense clause essentially pulls them together into one clause where they are separate clauses in the civilian agencies. The TAA also doesn't apply to small business set-aside procurement. So it may be that the small business set-aside world has in some senses the greatest impact from the Biden administration changes that are now underway. The key part of whether the TAA applies is whether the clause is in the contract. If it's not included, then the TAA does not apply. I will note that the TAA clause is in all GSA contracts. Like the BAA, the TAA includes a certification requirement that it has been that you're offering a product of a TAA certified, a designated eligible country, and thus there is potential False Claims Act liability for false certification. Next slide. The TAA contract clause requires supply of domestic or designated country materials. The test for domestic products mirrors the Buy American requirements, but I'll put this important footnote, is that the U.S. also, in essence, can be a qualifier or designated country. So a U.S. product can either meet the Buy American Act standard or it can meet the designated country product standard. The test for a designated country product standard is it's wholly the growth product or manufacture of a designated country or substantially transformed in the designated country. Next slide. Substantial transformation is essentially the customs test, and I give you the actual test there, the substantial change. The key part for purposes today is there is no second step, no cost of components test. It is purely a one-step, was there substantial transformation in the designated country. It is a very fact-specific analysis. We look to customs decisions often for guidance in those areas. Next slide. The Trade Agreements Act is enforced those certificates of compliance that I mentioned. Again, as I pointed out earlier, False Claims Act exposure, including treble damages that Matt went through for you earlier, can very much be implicated, as well as default termination for breach of contract and replacement with compliant goods for the non-compliant goods if there's a breach of that certification. that concludes us on our trade agreements. We'll turn briefly to the Federal Highways Buy America. I wanted to give you just an overview there so that you have a flavor of what the Buy America regime looks like. And I think that the Federal Highway Administration is going to have the greatest impact out of the infrastructure bill because of the changes that I'm going to mention. Next slide. Under the Federal Highways implementation of Buy America, it applies to steel and iron products permanently incorporated into a highway project. It does not include other manufactured products based on the 1983 ruling. As a result, essentially all that I told you about in the Buy America world and the trade agreements world about manufactured products has never really been implemented in the Buy America regime at Federal Highways. By contrast, at Federal Transit Administration, they have had a very elaborate Buy America regime that covers manufactured products, construction projects, and the like that, as I'll explain in a moment, I think is likely to become the basis of what Federal Highways will have to go to if the infrastructure bill is enacted. Next slide. I give you there the general rules for how it works for iron to steel products, in many respects parallel, but with some differences from the Buy American Act analysis that I went through for you. Next slide. As to manufactured products, really the only thing you have to show, it's not predominantly iron and steel. So, for example, things like gen sets, that's sometimes difficult to do, and other kinds of manufactured products like that. But then you have to go through this detailed analysis of what the parts are composed of to be able to reach that determination. But once you can show it's not predominantly iron or steel, then there is no application of Buy America at Federal Highways. Next slide. Not surprisingly, the Biden administration Made in America office has specifically told Federal Highways to re-examine that. So they're now undertaking that process. And I would have to assume that the waiver is probably ripe for withdrawal, even if the infrastructure bill doesn't pass. I don't think it would happen overnight because it would have to be it would have represented a major change in state procurements that are under federal highway grants. But I have to say that that is certainly one that is almost certainly on the horizon. Next slide. And I give you there, again, the test of if it doesn't qualify for a manufactured product, if it's withdrawn, how you would go through the analysis. Again, this is all to be determined, but we can see there will be that type of tracing analysis possibly in the process. So this could be a very complicated rule for highway and construction firms. And finally, the 2021 infrastructure legislation. The bill passed on August 10th. As I mentioned, it has that new uniform produced in the U.S. standard and waiver standards and process. Federal highways will certainly be expanded to the manufactured products and construction materials. And thus, I think it would require, if the Biden administration doesn't force the withdrawal of the waiver, a whole new set of rules for federal highways and more rigorous standards. Thank you.
And David, thank you so much. I know that we were going to wait and have all questions at the end, but there have been a few that have come in, and I know that you have to go somewhere. So I was wondering if I could ask you a few now, because you did such a great job on your time.
Certainly.
Okay, so one of the questions is, if a contract contains a specific older version of the BAA or TAA clause, do those still apply even though there's new versions that are going to be enacted?
Yes, they do. The contracting officer is required to update it if the contract member wanted to apply that. And the challenge, though, would be because if they tried to change it, essentially, think of it as a price evaluation analysis. The price evaluation is moot. So, in effect, essentially it becomes a moot issue, but the underlying answer is yes, it would require contract modification.
Great. And then and we see this often, if a contract contains both the Buy American Act and Trade Agreements Act clauses, how does a contractor comply with those?
Well, it depends. Again, in essence, what that's anticipating is there could be an offer below the BAA-TA threshold. And so if the offers all came in, the Buy American Act would apply at below the thresholds. If it's above the threshold, the TAA is going to comply. Now, it would seem to us that would be an ideal circumstance for either a inquiry to the contracting officer or arguably a protest, because the contracting officer is supposed to be able to make that determination of the likely contract value, because, as I pointed out, the regimes are so different. And going into it, you'd want to know, is the price differential going to apply or is it not? Or are we limited to designated country products only? So if that's the circumstance, I would say consider a contracting officer inquiry and potentially a protest.
And then the last question, how do you certify that a product is domestically produced? Is it similar to USMCA approach where the harmonization codes are changed through the manufacturing process?
I would say no. It would require a detailed bill of materials analysis of the components, if that's what the applicable test, if it's a two-step analysis. If it's as to the manufacturing process, we have looked both at GAO decisions, we have looked at Court of Federal Claims decisions, and we also looked at customs decisions as to the definition of manufacturing as to a specific product.
Great, thank you, David. Really appreciate that. As David mentioned, I think we're only going to see more of these issues come up. And this is an area where it's very difficult for contractors to comply with the Buy American Act and the cost of components test. And putting in place some mechanism at the outset to track the cost of components and to track country of origin of components really goes a long way towards compliance. It's very difficult to do that afterwards when the governments come in and investigate it, as we've seen. So it's important to pay attention to this on the front end rather than trying to recreate it on the back end.
Absolutely.
Okay, well, that brings us then next to Julia, who is going to talk to us today about the Department of Defense enhanced debriefings, which have come about, I think, since our last presentation, and various other bid protest updates. We are often contacted to assist with bid protests, and Julia is the right one to help navigate you through that process. So, Julia?
Thanks, Erin. So I'm going to talk about a variety of bid protest related topics today. So first, I'll talk about debriefings and specifically DoD enhanced debriefings, how those work right now, and then some upcoming developments to be expected with those. And then I'll talk about some recent protest decisions, a couple Court of Federal Claims and GAO decisions on the same procurement that were at odds over how to resolve the protest, a couple of GAO decisions about evaluation of compensation of professional employees, and then I'll talk about some recent joint venture rules and GAO protest decisions about those. So before I talk about DoD enhanced debriefings, I wanted to just do a brief refresher on required debriefings and when they're required and when they're not. So debriefings are required for two types of procurements. Those are negotiated procurements that are handled under FAR Part 15, and then orders under indefinite delivery, indefinite quantity, or IDIQ contracts. And a debriefing on those types of procurements is considered required if it's requested by an offeror in writing within 3 days after notice of award. And then specifically in the context of IDIQ contract orders, the order itself must exceed $6 million for that debriefing to be required. So it has to be requested by the offeror, be over that threshold if it's an IDIQ order, and it has to be one of these two types of contracts for the debriefing to be considered required. That means that in all other contexts, debriefings are not considered required, even if the agency provides a debriefing to an offeror. That would not be a required debriefing. So that means that commercial items procurements under FAR Part 12, orders under GSA schedule, multiple award contracts, that's FAR Part 8, simplified acquisition procurements under FAR Part 13, and sealed bid acquisitions under FAR Part 14. If any debriefing or debriefing-like information is provided to an offeror in connection with those types of procurements, they're not considered a required debriefing. And I'll talk about the impact of what it means to have a required debriefing on protest timing. But first, I wanted to touch on the current rule that applies for DoD enhanced debriefings. And what makes them an enhanced debriefing is that offerors can submit to DoD written questions after the offeror receives a required debriefing. So if the debriefing is handled over the phone or even an in-person meeting, or it's just information that is provided to an offeror, after that is provided, the offeror would have 2 business days to submit additional questions to DoD or DoD agency, and then the debriefing would stay open until DoD responds to those post-debriefing questions. So that's different than how debriefings work for civilian agencies, and that's something that is part of the DoD enhanced debriefing. So why am I talking about debriefings in the context of protests? Well, not only do debriefings give you information about how a procurement was handled, it might give you grounds for filing a protest or make you think that you have grounds for filing a protest, but a debriefing also impacts the timing of protests that are filed with the Government Accountability Office, or GAO. Generally, post-award protests are due to GAO within 10 days after the basis of protest is known or should have been known, whichever those 2 dates is earlier. But there are a couple exceptions to that rule, and one of them is that if a required debriefing is provided to an offeror, then the protest is due within 10 days after the debriefing is concluded. And again, I said the word required debriefing, meaning that it has to be one of those that is considered a required debriefing, not just that a debriefing of any kind is provided to the offeror. And that means that a protest can't be filed before a required debriefing is provided to an offeror. If you do that and you file a protest before you get the debriefing, it'll be dismissed as premature, and then you could still file a protest later, but you would have wasted a little bit of effort filing early. Debriefings are also important to whether you can get an automatic stay of the awarded contract that's triggered by filing a protest at GAO. If you file the protest within certain time frames, then the agency will be automatically required to stay performance of the awarded contract, which is something that can be very beneficial when you're filing a post-award protest. In the context of a civilian procurement, so a non-DoD procurement, you can get an automatic stay of the awarded contract if the protest is filed within the later date of either 10 days after the award date or 5 days after a required debriefing is held or provided. So if there is a required debriefing, then the protest would need to be filed within 5 days after that's held. In the context of DoD procurements, the timeframes generally work the same way, except that if an offeror does submit post-debriefing questions to the agency, and they submit those within the 2 business days after the debriefing, then the protest would need to be filed within 5 days after the agency responds to those questions to be able to get a stay of the awarded contract. So just remember that in the context of DoD procurements, the debriefing stays open until those questions are answered. And there was a little bit of ambiguity about whether the 2 business day period after a DoD debriefing happens when an offeror could submit post-debriefing questions, whether that keeps the debriefing process open if the offeror ultimately doesn't submit any questions. And in this Nika Technologies case that went up to the Court of Appeals for the Federal Circuit, the offeror didn't submit any post-debriefing questions on a DoD procurement, but they filed their GAO protest 5 days after the second business day after the debriefing. And ultimately, the agency didn't issue the stay of the awarded contract, and the issue went up on appeal to the Federal Circuit, and the Federal Circuit held that 2 business day period doesn't keep the debriefing open if the offeror doesn't submit any post-debriefing questions. So that means that if you don't submit any post-debriefing questions, your debriefing closed the day you received the debriefing or the day the debriefing was held. And to get that automatic stay of performance, you need to file your GAO protest within 5 days after the date of the debriefing. The enhanced debriefing DoD rules that I've been talking about right now are implemented through a statute and then a DoD class deviation to the DFAR. So they're not actually part of the Defense FAR supplement or the DFARs, but there was a proposed rule recently issued that would add these rules and provide a little bit more context of how they'll be implemented. There are some potential ambiguities in these proposed rules, and I won't go into a lot of detail with them, but hopefully one of the things that will be ironed out once the final rule is issued is the issue that I was just talking about whether the debriefing stays open for that 2 business day period when an offeror could submit questions, but then ultimately doesn't submit questions. Hopefully that'll be clarified by the final rule. And this final rule also would add a separate aspect of the DoD enhanced debriefing, and that is a requirement that DoD agencies provide a redacted source selection decision document as part of the debriefing in 2 circumstances. One is if a small business or non-traditional defense contractor requests it and the contract has a value of more than $10 million but no more than $100 million, or if the contract has a value over $100 million, no matter the type of offeror, and they don't have to request it. So this redacted source selection decision document, because it's redacted, it probably wouldn't have as much information as you probably would want to see if you're an offeror who is getting a debriefing, but it is more information that you're probably getting right now in a debriefing. So I think this is a good development, and hopefully will give more insight into the procurement process for at least for DoD contracts. All right, so I'm going to switch gears a little bit and talk about some recent protest decisions. So the first I will talk about are a couple of GAO and Court of Federal Claims decisions on the same procurement that came out different ways on how the agency should have addressed the issue in the protest. So this saga started with a protest filed at GAO by Vectrus Mission Solutions Corporation, or Vectrus, and it was challenging the evaluation of its proposal and the award of a task order to a company called VS2 LLC. I'm not going to go into a lot of detail about the merits of the argument at issue in Vectrus's protest, but essentially the issue was that if Vectrus's evaluated price was lower than VS2's evaluated price, then Vectrus would be in line for award. But during the evaluation, the agency found that VS2's evaluated price was lower than Vectrus's evaluated price. Vectrus's GAO protest was successful. GAO agreed with Vectrus that the evaluation and award decision was not correct. And the GAO recommended that the agency award the task order to Vectrus if otherwise proper, and that the agency terminate the task order originally awarded to the awardee, which was VS2. Now, this is not a typical type of GAO recommendation when GAO sustains a protest, because GAO usually isn't so direct about recommending that the agency award to a specific offeror. But in these circumstances, GAO felt that it was appropriate that Vectrus was likely the eligible awardee if otherwise proper. So unsurprisingly, the agency followed GAO's recommendation and awarded the task order at issue to Vectrus and terminated VS2's task order, essentially flipping the position between Vectrus, the unsuccessful offeror, and VS2, the awardee. So as you can imagine, VS2, I think, was not happy with that outcome, and VS2 filed its own GAO protest after the agency awarded the task order to Vectrus. And VS2 was arguing that the agency shouldn't have just blindly accepted the GAO's recommendation, and that the agency should have reevaluated Vectrus's proposal before making any sort of award decision. GAO actually considered the protest to be a challenge to GAO's recommendation rather than the agency's implementation of that recommendation. and GAO dismissed the protest as untimely. And that's because GAO has a mechanism for hearing requests for reconsideration of its protest decisions, which in this case would include its recommendation of how to address the protest issue. But requests for reconsideration must be filed within 10 days of when GAO issues its decision. And in this case, VS2's protest was filed more than 10 days after the Vectrus GAO decision was issued. So GAO dismissed VS2's protest. And the saga continued more. VS2 then filed a Court of Federal Claims protest, making the same arguments that it made in its GAO protest. In contrast to GAO, the Court of Federal Claims found that VS2's protest was timely because it was the court considered it to be a challenge to the agency's award to Vectrus, not a challenge to the GAO's recommendation. And also, the Court of Federal Claims doesn't have as strict timing requirements for protests as GAO, with GAO typically requires protests, or in this case, a request for reconsideration to be filed within 10 days. So ultimately, the Court of Federal Claims agreed with GAO that there was an error in the award decision and that there was some action that should be taken, but the court agreed with VS2 that the agency shouldn't have just implemented GAO's recommendation and made award to Vectrus without doing any other sort of reevaluation. So ultimately, VS2 prevailed in getting the court to order the agency to reconsider the award decision. I think it's, I don't know yet whether the agency has changed its award decision and made a different award, perhaps to VS2, but I think these cases are really illustrative of the different ways that the GAO and the Court of Federal Claims can approach a procurement, even the same procurement, and also just an important reminder that if your award has been challenged, you should intervene in the protest and make sure if you have an issue with anything that's happening in the protest process that you consider whether you should file a protest or, in this case, a request for reconsideration. All right, the next couple of cases I'll talk about are in the context of protest of compensation of professional employees, and these are solicitations that include FAR Clause 52.222-46, which involves evaluation of compensation for professional employees. This clause is included in services contracts that will include a meaningful number of professional employees, and if the contract is over $750,000. This clause might be overlooked by some offerors because it sometimes is buried in the list of FAR clauses rather than something that is an explicit proposal instruction, but offerors are required to submit a total compensation plan, including proposed salaries and fringe benefits for the professional employees that'll work on the contract. If this clause is included in a solicitation, the agency must evaluate the proposed professional compensation to see whether it's realistic and whether the offeror, if awarded the contract, would be able to attract employees and competent employees who'd be able to perform the professional services at issue in the contract. So there were two recent GAO decisions that illustrate how this clause can give rise to protest issues. And the first was the Bionetics Corporation. Bionetics Corporation filed a post-award protest, first arguing that the agency failed to conduct a realism evaluation under the professional compensation clause. GAO dismissed this argument because, in GAO's view, it was an untimely protest ground brought after award because the solicitation, although it included the professional compensation clause, it also stated that the agency would not be conducting a realism evaluation of any kind. So you had two terms at issue in conflict in the solicitation. One, the professional compensation clause that requires a realism evaluation, but another statement in the solicitation that said the agency would not conduct a realism evaluation. GAO ultimately held that because no one filed a pre-award protest challenging that ambiguity in the solicitation, the agency only had to do what it said it would do in the solicitation, which was that it wouldn't perform a realism evaluation. So that post-award protest, GAO found to be untimely. the Bionetics Corporation also raised another argument, and that was that the professional compensation clause requires the agency to compare the professional compensation of the incumbent contractor to the professional compensation that offerors proposed. And in this case, the solicitation wasn't very clear about what sort of information offerors needed to include about their compensation, but the protester and the awardee both provided unburdened labor rates and fringe benefits for their professional employees that the agency could have evaluated, but in this case it did not. So GAO ultimately sustained that protest ground and recommended that the agency go back and evaluate the proposed compensation plans and compare them to the incumbent compensation plans to see how they compared. So that's just an illustration that even though this clause was in the contract, the agency didn't seem to, or the clause was in the solicitation and the agency didn't really seem aware of what they had to do and how they had to evaluate proposals. So that was a good protest ground in that case. The other GAO case recently on this issue was Criterion Systems, Inc. That was also a post-award protest. And in that case, the protester argued that the agency failed to compare the offeror's proposed compensation plans to the incumbent compensation plan. GAO, like in the prior protest, GAO dismissed this argument as untimely because it wasn't brought before award, because in this case, the solicitation informed offerors that the agency didn't have the actual labor rates or benefit information of the incumbent contractor. So it couldn't perform a comparison with the incumbent contractor compensation information. Instead, the agency said it would compare offerors' proposed compensation plans to the government estimate, which was included in the solicitation. So in this case, because no one challenged any aspect of the solicitation before award, all the agency had to do was the evaluation that it said it would do in the solicitation. Criterion Systems also made another argument related to professional compensation, and it challenged the agency's realism evaluation that was performed under the professional compensation clause. In this case, GAO denied that aspect of the protest because the agency did perform a realism evaluation. It looked at the awardees' labor rates and compared them to the government estimate, and it looked at other aspects of the compensation plans. And ultimately, the protester was just disagreeing with the conclusion that the agency reached. It wasn't arguing that the agency didn't conduct a realism evaluation. So in this case, the agency did what it was required to do under the professional compensation clause. And then I'll switch gears again and talk about some recent joint venture rules, and then there were a couple GAO cases interpreting those rules that give some more insight into how those rules are implemented. So the first one is stemming from the 2020 National Defense Authorization Act, which prohibited DoD from requiring a joint venture to hold a facility security clearance if the individual members of the joint venture have the required facility clearance. So this is different than how joint ventures typically are required to operate, where if a joint venture is bidding on a contract and the contract requires a facility security clearance, typically the joint venture offeror itself would also be required to have a facility security clearance. And this statute changed that rule, at least in the context of Department of Defense agencies. The Small Business Administration issued a regulation that implements this statute in the context of small business joint ventures. That, again, this would apply to all agencies, not just Department of Defense agencies, but this regulation would prohibit requiring the joint venture itself to get a facility security clearance if the individual members have it. And the Small Business Administration regulation even provides that a clearance might not be required from all joint venture members if only part of the work requires security clearance. Then in that case, only the individual members that will perform that work would need the facility clearance. So not the joint venture itself doesn't need clearance, and maybe not even all the members need it. So there was a recent GAO protest on this issue. InfoPoint LLC filed a pre-award protest challenging an Air Force solicitation that required a joint venture offeror to hold a top secret facility security clearance at the time the proposal was submitted. GAO sustained this protest, so GAO agreed that this aspect of the solicitation was contrary to law because the Air Force could not require the joint venture to have the clearance if the joint venture members individually had the top secret security clearance that they needed. And GAO ultimately recommended that the Air Force remove that aspect of the solicitation. And so just to allow offers to be qualified for award or eligible to bid on the contract if the individual members held the top secret security clearance. And another joint venture rule in the context of joint ventures between SBA-approved mentors and proteges would be is 13 CFR 125.8 parentheses E, and that is that when an agency is evaluating the proposal of a joint venture between a mentor and protege, the agency must consider the work done and qualifications held individually by each joint venture member, as well as the work done and qualifications held by the joint venture itself. And critically, this regulation includes language that says that an agency may not require the protege firm to individually meet the same evaluation or responsibility criteria as that of required of other offerors generally. So this makes perfect sense in the context of a mentor-protege joint venture where a mentor and protege are joining together to pursue a contract that the protege likely wouldn't be able to qualify for by itself. Then it wouldn't make sense to require the protege to meet the same sort of experience or other qualifications that all other offerors have to meet. And solicitation that included a requirement that solicitation that required a protege to meet the same experience requirements as other offerors was challenged in the Innovate Now LLC protest. This was a pre-award protest that GAO ultimately sustained because the language of the solicitation was contrary to this regulation. Specifically, the solicitation required offerors to submit work samples as evidence of their experience, and a joint venture offeror had to have at least one work sample that met the same requirements as a work sample provided by any other type of offeror. And GAO held that this was contrary to the regulation because it required the protege member to have the same level of experience as all other offerors, which is not permitted by the SBA regulation. And just to wrap up, just to give you some tips to remember when you're going through the procurement process and you're thinking about whether you might need to protest something. So first and foremost, review the solicitation and make sure you understand what is required to be included in your proposal and then what the agency will evaluate. This will not only help you qualify for award, but also if you need to file a protest later, you want to make sure your proposal includes all necessary requirements. And then if your award is protested, you don't want to lose out because there's some sort of something missing from your proposal or something you didn't consider. And then when you're reviewing that solicitation, consider whether you want to pursue a pre-award protest. If the solicitation terms are improper or restrictive of competition, or there's something else about them that's ambiguous or have some other issue, that is something that has to be challenged before award and before proposals are due. So make sure you're thinking about that on the front end when you're thinking about proposals, rather than waiting until after award. As we saw with the professional compensation cases, if you wait till after award to challenge the terms of the solicitation, it can be too late. After award, make sure to timely request a debriefing if a debriefing is required, and be aware of when a protest would be due to be timely, but also to get a stay of performance if you're filing at GAO. It can be confusing even just to figure out whether a debriefing is required, so you'll want to make sure you're aware of all of the appropriate timing requirements and the turnaround after a debriefing between when a protest would be due to get a stay is only 5 days. So that can be a tight time frame. And if you're the awardee and your contract or task order was protested, it's usually important to intervene in the protest. So your attorneys can be involved in the protest and keep an eye on what's happening. They can make arguments on your behalf in support of the award. And then you'll also be well aware of any decisions that come out that you would potentially want to challenge. And along that same lines, if a GAO makes a recommendation that is contrary to your interests, or if an agency takes corrective action and that is contrary to your interests, consider filing a protest soon after you find out that information about how an agency is going to respond to a protest, because if you wait until the agency implements their action, it might be too late. So it's always important to make sure you consider whether you need to protest right now. And with that, I will turn it back over to Erin.
Thank you, Julia. That was fantastic. There are two really difficult conversations we have with clients. There's many, but one has to do with us them calling us and then being too late to get the automatic stay because they waited too long to contact us. And then the other one is if they come to us after award with a solicitation defect that they want to protest. Those are difficult conversations to have. We encourage you to avoid those conversations by reaching out to us and ask your questions earlier rather than later. And when I say us, I mean Julia and David Ralston and Frank Murray in our DC office. I am not our bid protest guru. I'm just dangerous enough to talk about it and then send you to them. So thank you, Julia. Next, we are going to do our next CLE code. Very, very exciting. So this is the second CLE code, and if you want CLE credit, you need to enter it in the box and then hit submit. So that code is Y as in yellow, the number 5, X as in X-ray, J as in Joe, and L as in Larry. That is Y as in yellow, the number 5, X as in X-ray, J as in Joe, and L as in Larry. Last time, Y, 5, X, J, L. We're going to leave the box open briefly, and then you can go ahead and enter that. So now is the moment that some of you have been waiting for, which is our discussion of the government's new vaccination requirements. Now, I was anticipating this topic to be about just a general regulatory update, and then a few weeks ago when I saw that this was happening, I waited to do my slides and waited, and I'm glad that I waited because really, there's a lot here to talk about and present on, and so the vaccination requirements have completely superseded any other topics, basically, that I wanted to talk about with you today. So let's get started. On September 9th, President Biden issued an executive order called Ensuring Adequate COVID Safety Protocols for Federal Contractors. The stated purpose is to ensure that parties that contract with the government provide adequate COVID-19 safeguards to their workers for performing on or in connection with a federal government contract or contract-like instrument. And we'll break all that down. What's the purpose? To decrease the spread of COVID. There's also some stated purposes to decrease worker absence, boost efficiency. I will tell you that my personal read of this is that the goal is to get as many people vaccinated as quickly as possible. And one of the levers the federal government has to do that is through federal funding. So as we talk about the requirement, the executive order, and the guidance implementing the executive order, there is not a rational basis between the performance of the contract and who has to get vaccinated and who is subject to these requirements. So I want you to let that go and focus on what the order and task force guidance says about who this applies to. Again, they're going to take a very broad brush approach because the goal is to get as many people vaccinated as possible. The requirements in the executive order state that they take precedence over any contrary state law or local law or ordinance, which is not surprising given federal supremacy. However, if there are some more restrictive state laws or municipal ordinances, then contractors still need to comply with the more restrictive requirements. Also, if a contractor is performing work at a federal building or a federally controlled workplace, potentially a federal construction site, something along those lines, there might be additional COVID safety requirements that apply to employees who are working at those facilities. The executive order requires the development of a contract clause by executive departments, agencies, and independent establishments. And the clause needs to require contractors and subcontractors to comply with guidance published by the Safer Federal Workforce Task Force. When the executive order was issued, there was no such guidance. We have since seen such guidance, and we'll talk about that today. The guidance does need to be approved by the director of OMB, and it applies to all workplaces in which an individual is working on or in connection with a federal government contract or contract-like instrument. So this is the verbiage that came from the executive order. The executive order also requires the FAR Council to issue a FAR clause by October 8th, 2021. And we've already seen deviations to the FAR and DFAR and some clauses related to the FAR and DFAR to implement this executive order, as well as I will talk about a GSA that has come out as well. As we're seeing in the draft clauses that are in the deviations, they reference the task force guidance, they reference the website where the guidance is, and so therefore the clause doesn't need to change as the guidance changes. The difficulty right now is the guidance was issued along with a variety of FAQs, and when the FAQs change, they don't really have dates next to them. There's already been one additional FAQ since they initially came out on September 24th, and there's just a little new comment next to it. So it's a little difficult to figure out what's new, and who knows how long that new comment will stand out there. So the task force guidance that I just mentioned, it was issued on September 24th. And it contains a series of definitions. And I'm going to walk you through each of these definitions, and we're going to go through some practical examples, because the definitions really incorporate other definitions, so it's hard to figure out how they work together. But we think we've figured it out the best we can. There's still a lot of open questions. So the task force guidance requires covered contractors to ensure that their covered contractor employees are fully vaccinated against COVID-19 by December 8th, 2021. They also need to ensure that covered contractor employees and visitors comply with masking and physical distancing requirements at covered contractor workplaces. And they're also required to designate a COVID-19 workplace safety coordinator or coordinators at covered contractor workplaces. The bold and italicized words are specifically defined in the guidance, and we'll talk about them. But I continue to bold and italicize them to help you circle back. So a covered contractor is a prime contractor or a subcontractor at any tier. So this flows down throughout the supply chain, does not stop at first tier. It flows down throughout, who is a party to a covered contract. Okay, well then what's a covered contract? A covered contract is a contract or contract-like instrument that includes a vaccination contract clause. That part is very important. We're going to talk about what is a contract or contract-like instrument. But note that the definition of a covered contract is one that includes the vaccination contract clause. We've gotten inundated with questions. Does this apply immediately right now? No, it does not apply to existing contracts until that contract is modified to include the clause, at which case it would then become a covered contract. The government has determined that the terms contract or contract-like instrument have the meaning that are set forth in the Department of Labor's proposed rule that applies to minimum wages for federal contractors, as well as any changes that might occur to that proposed rule. It basically is going to cover an agreement between two or more parties, creating obligations that are enforceable or otherwise recognizable at law. So it's pretty much a basic definition of a contract. It includes, but it's not limited to, a mutual binding legal relationship that obligates one party to furnish services, including construction, and another party to pay for them. So the key premise is that it's a contract for services, including construction. It includes procurement contracts, prime contracts, and subcontracts at any tier subject to the FAR. It does expressly include cooperative agreements, lease agreements, licenses, permits. We go on. Job orders, task orders under basic ordering agreements, letter contracts, purchase orders, exercise contract options, and bilateral contract modifications. It expressly includes contracts covered by the Service Contract Labor Standards, formerly known as the Service Contract Act, and the Construction Wage Rates Requirements, formerly known as Davis-Bacon Act. It includes concessions contracts, as well as contracts in connection with federal property or land. So a lot of types of contracts are expressly covered by the guidance. What is not expressly covered? What is not a covered contract? I think it's easier to talk about this list than the other list. Contracts that are for the manufacturing of products. It's interesting the guidance uses the terminology manufacturing of products when it talks about prime contracts, and then it used the terminology solely for the provision of products when it relates to subcontracts. So it doesn't apply to prime contracts for the manufacturing of products. It's clear it doesn't apply to subcontracts solely for the provision of products at any tier. Was there an intentional difference between provision of products and manufacturing of products? I would think the only category that leaves open is, would it apply to a reseller, a distributor who's maybe selling a product that they themselves did not manufacture? I doubt that's the intent, only because when a government is soliciting a product and needs to decide whether or not to include the vaccination contract clause in the solicitation, they go by the product, not whether or not the person they're buying it from is in fact the manufacturer. So that remains to be seen, as it's just a loose terminology there. The FAR clauses and the FAR deviation and DFAR deviation have picked up on the manufacturing of product language. Covered contracts also do not include contracts and subcontracts equal to or less than the simplified acquisition threshold, which is currently $250,000. It also expressly does not apply to grants or contracts and contract-like instruments or agreements with Indian tribes under the Indian Self-Determination and Education Assistance Act. That's a pretty small category, so we're not going to talk about that too much today. Also, when we talk about contracts, if the work is solely to be performed outside the United States by employees working outside the U.S., then it would not apply to those contracts. It includes the United States and its outlying areas. I'm just going to refer to it for ease of presentation as the U.S., but keep in mind it does include various outlying areas, and that definition is pretty established in the FAR. So I just told you those are not covered contracts. So you're sitting there going, phew, I only sell products to the government. I'm selling at or below the simplified acquisition threshold. I'm clear. It doesn't apply to me. Well, while it's not a required clause for those contracts, agencies are strongly encouraged to include the clause in contracts awarded prior to the date on which it's required, and we'll talk about those dates, contracts at or below the simplified acquisition threshold, as well as contracts and subcontracts for the manufacturing of products. So what this tells me is nobody is safe from the potential application of this clause, other than grants, and that seems to be pretty clearly exempt. In addition, a covered contractor who has to comply with the clause is strongly encouraged to include the clause in contracts with companies who employees perform work at their workplaces, even though it's not related to a covered contract. So the people who clean your office building, the contract you have with folks to provide security, food services, groundskeeping, it's strongly encouraged you include the clause in those contracts as well. Again, no rational relation to the performance of the government contract, but trying to reach as many people as possible, because the government's goal here is to get as many people vaccinated as possible. So going down the definition list, we figured out what a covered contract is, a contract and contract-like instrument, covered contractor. Well, then we get into covered contractor employees. And those are the employees that need to comply with the vaccination requirements. That is any full-time or part-time employee of a covered contractor who is either working on a covered contract or working in connection with a covered contract. Well, what does in connection with mean? The guidance says it includes employees who do duties that are necessary to the performance of a covered contract, but they're not directly engaged in performing the work required by the contract. So this is not actually the service individuals working on the contract. It's not your construction workers who are actually on the site doing construction work. Instead, this is your kind of administrative or overhead support that you typically have, what I would call your indirect costs to your contract. And the examples that are expressly included in the guidance include human resources, billing, and legal review. It's really important because those are covered contractor employees. Also, you're a covered contractor employee if you're working at a covered contractor workplace. Okay, well, even if you're not working in connection with a covered contract? So what I just said is one of the requirements that applies to covered contractor employees is that you need to be vaccinated, fully vaccinated by certain dates. So again, those are employees who are working on a covered contract, working in connection with a covered contract, or working at a covered contractor workplace, even if you don't do any work in connection with the covered contract. Well, what's a covered contractor workplace, and how do I know if I have one and how many I have? Well, it's a location that's controlled by the covered contractor, at which any employee of the covered contractor is working on or in connection with the covered contract and is likely to be present at that location during the period of performance of a covered contract. So the definition of covered contractor employee, those first two categories, if you have an employee who's working on a covered contract or working in connection with a covered contract, wherever their workplace is, if it's at one of a location controlled by the contractor, that becomes a covered contractor workplace. It does not include an employee's residence. So it's important for you to know that if you have an employee who's working on a covered contract and they are working from their residence, they still need to comply with the vaccination requirements, but they don't need to comply with the other requirements of social distancing and masking while at home. And also because the residence is not a covered contractor workplace, their family members there then do not have to get vaccinated. So there is a limit to the government's reach. It doesn't reach within your home, apparently. In terms of what is required, so we talked about covered contractor employees and covered contractor employee workplaces. And before I move on, I want to mention one other thing. Some of you might be thinking, well, we have 5 buildings on a campus, or we have 5 floors in a high-rise building. What if all the government contract work and the in-connection work is done on one floor or in one building of my campus? Does that mean that all the other buildings and floors also, the vaccination requirements apply to them? The guidance answered that question and basically said that as long as a contractor can affirmatively determine that none of the employees in the non-covered locations will come into a contact with a covered contractor employee, then no, those other floors, those other buildings do not need to have everyone there vaccinated. However, what do they talk about when they talk about, likely to come into contact? It includes common areas such as lobbies, elevators, stairwells, kitchens, parking garages, and they didn't expressly state it, but I would assume it might also include bathrooms. So let's say that I have 5 floors in this building, and one of the floors is actually only half a floor. I share it with other tenants. And we share the parking garage, we share the lobby, and we share bathrooms. Well, the other tenants won't need to be vaccinated, even though we share those common areas. But even though the government contracts work is only done on my floor, those other floors might be tainted as well because they use the same parking garage or lobby or potential cell in the event of an emergency and we can't use our elevator. So you can see how broad this extends, and I think that really some of the government's goal here is to make this so complicated to figure out and parse out some sections of your business that don't need to be vaccinated that it's just easier to apply it to all your locations. So we talked about covered contractor employees and covered contractor workplaces. Well, what's required for those underneath the guidance and the executive order? So covered contractor employees must be fully vaccinated unless they're legally entitled to a religious or medical related accommodation. And if you want to know what could qualify for that, how to make that determination, that's going to be made by the company. And I have fantastic employment law lawyers who can walk you through those process. So the standard is that they need to be fully vaccinated by December 8th or the first day of the period of performance of a new covered contract or option extension on a covered contract that contains a vaccination clause, if that's later than December 8th. Fully vaccinated means 2 weeks after the second dose of a 2-dose series of a vaccine or 2 weeks after receiving a single-dose vaccine, such as the J&J shot. Right now, there's no expiration once you're fully vaccinated, but it did leave open the opportunity for task force guidance to potentially change with all the booster shots we're seeing, where maybe you might not be considered fully vaccinated until after you receive a booster shot. We're not there yet, but they left open that potential. Also, recent antibody tests will not prove vaccination status. So if you had COVID a month ago, it doesn't matter. You would still need to get fully vaccinated. And there's no COVID testing requirement in lieu of the vaccine requirement. So some of the other requirements that you're seeing come out applying to large employers or OSHA, they might have COVID testing requirements in lieu of vaccines, not with the federal government contract mandate. It is going to be a vaccine, and that's a full stop, no testing requirement. So the only exemptions would be that religious or medical related accommodation. There is a very kind of stopgap exception if the agency has an urgent mission critical need for covered contractor employees to begin work on a covered contract. However, the contractor must fully comply within 60 days of beginning that work. And we're going to talk about masking and social distancing requirements. Those would still apply to the covered contractor workplace in the interim. In terms of what's required for proof of vaccination, you cannot rely on self-attestations. You do need the vaccination card or other immunization records. You don't need the originals, and it could be provided electronically, so PDF is fine. So then let's talk about what are those masking and social distancing requirements. So the vaccination requirements, I think, and most folks the most heartburn because the masking and social distancing we've all been living with for quite some time, and many companies are already used to doing that. So the masking and social distancing not only applies to employees at covered contractor workplaces, but it's also going to apply to your visitors. And what is required is going to be dependent on the community transmission level that is in the CDC COVID-19 data tracker County View website. So if you are in a county that is at high or substantial community transmission, even for your employees who are fully vaccinated, they will need to wear masks in indoor settings, but they don't need to socially distance. They don't need to worry about that. If you have employees or visitors who are not fully vaccinated, they need to wear masks indoors in certain outdoor settings and socially distance for at least 6 feet in offices, conference rooms, and communal workspaces. If you think through this, if you have a covered contractor workplace and everybody has to be vaccinated, the not fully vaccinated category is going to apply to those with accommodations as well as visitors for the most part. Everybody else, according to the clause, will need to be vaccinated. If you're in a county with low or moderate community transmission, if you're fully vaccinated, no masks, no social distancing. If you're not fully vaccinated, same rule, masks indoors, certain outdoor settings, and socially distance. There are some specified exemptions or exceptions. One of them, for example, is if you're alone in your office with a closed door, or if you're engaged in activity where your mask may get wet as part of your job responsibilities. So if you want to know about those exceptions, they're in the guidance and you can look at it there. The third key requirement by the guidance and the contract clause and the executive order is to designate an individual or individuals to coordinate the implementation of compliance with the guidance. And so they're the ones who are going to be distributing information to covered contractor employees about what is required and why, and any other individuals who are likely to be present at covered contractor workplaces. Those are your visitors. They are going to communicate required safety protocols and related policies, and they're going to post signs at covered contractor workplaces. And last, they're going to be responsible for collecting the proper vaccination documentation and maintaining that. So you have a record if there's a question as to who is and is not vaccinated. So I'm a little excited about this because, you know, we went through a lot of definitions, and if you're hearing for this for the first time, it's really confusing. So I came up with an example here, and so bear with me. This is Alphabet Company. An Alphabet Company has a construction contract with the Department of Defense, and you can see on the screen there the construction site. They have various office locations, and for purpose of this, to simplicity's sake, we're going to assume that they're all in different states, so we don't have a kind of they're all in the same campus type issue. We have employee A who is at the red building. They're the foreman for the DoD construction contract. So while they go to the site on a daily basis or frequently, they're also likely to be present in their office in the red building. Because of that, because they will be working in the office in the red building during the period of performance of the covered contract, all employees at the red building will need to be vaccinated, and the red building needs to comply with the masking and social distancing requirements. Then we have employee B, who works at the Orange building, and employee B does all of the billing for the DoD contract. Might only make up 5% of the work they do on a routine basis, but that's what they do. They do the billing. According to the guidance then, just because employee B is at the Orange building, all employees at the Orange building will need to be fully vaccinated, and everyone at the Orange facility will need to comply with the social distancing and masking requirements and guidance. Employee C works at the yellow location, and there is nobody who works at the yellow location who works on a covered contract or in connection with a covered contract. Trust me, we searched high and low. Nobody touches that construction contract there, even tangentially. Employee C will not need to be vaccinated. None of the employees at the yellow facility will be required to be vaccinated, and the yellow facility will not need to comply with the social distancing, masking guidance, or requirements in the guidance. Not to say they don't have to comply with anything, because there's other laws that will govern them, but at least for the purposes of the clause, the yellow building will not need to comply. Then we have employee D, who is the project manager for the construction project for this D contract, and she works from her residence. So employee D is going to need to be vaccinated, but her family members she lives with do not need to be vaccinated. And when she's at home, she does not need to socially distance from her spouse or her children or wear masks around them, even if she may want to do so. She's not required to. Employee E, that's a tough one, does not work on the covered construction contract, does not work in connection with the construction contract, and works from home. Employee E will not need to be vaccinated. And then we have the construction site. All employees of Alphabet Company who work at the construction site must be fully vaccinated, and they must comply with the masking and social distancing requirements dependent on the level of community transmission for that construction site. Also, since it is a federal building that they are working on in a federal facility, they may need to comply with additional safety protocols applied to work at a federal facility. So I hope that demonstration and walking you through those examples will help you kind of see how this is in practice. So we've seen on September 30th, the FAR issued a class deviation, and they confirmed that the contract clause in the deviation applies to solicitations and contracts for services, including construction. They identified when agencies are required to include the clause. That's in new contracts awarded on or after November 14th, assuming the solicitation was issued before October 15th. And that's going to include new orders that are awarded under existing indefinite delivery contracts. So if you have an IDIQ contract and you get an order after November 14th, you can expect to see the vaccination clause in the order, assuming it's over $250,000, assuming it's for services, even if it's not in the IDIQ contract. The clause will also be seen in new solicitations issued on or after October 15th and contracts awarded pursuant to those solicitations. Again, those include solicitations for orders under multiple award IDIQ contracts. The solicitation and new contract issue is the easier one, because when you're bidding on a solicitation, you will know whether or not the solicitation includes the new vaccination clause. Where we've been running into more difficulty is for companies to ascertain whether their existing government contracts will be modified to include the clause, and if so, when. Well, the guidance from the FAR Council is that extensions or renewals of existing contracts and orders that are awarded on or after October 15th should include the clause, as well as options on existing contracts and orders exercised on or after October 15th. So again, we should expect to only see it in those contracts for services or construction that are existing. However, agencies are still strongly encouraged to include the clause in contracts awarded before November 14th, in solicitations issued prior to October 15th, and in contracts not covered or directly addressed by the executive order, including those under the simplified acquisition threshold of $250,000, and contracts or subcontracts for the manufacturing of products. So again, no contract really, from a procurement standpoint, appears to be safe. Other than, again, it doesn't apply if the work is solely done outside the U.S. It does not apply to employees performing work outside the U.S., as well as the Indian tribe exception, although the FAR Council did clarify that it will apply to procurement contracts or subcontracts under the FAR awarded to an Indian-owned or tribally owned business entity. That's not the same exemption as those that are under the Indian Self-Determination and Education Assistance Act. That's a separate category. So if you're an Indian-owned or tribally owned business entity, you want to make sure you understand that distinction. The Department of Defense also issued a class deviation for the DFAR on the same day. Theirs was a little bit clearer, I think, in its application, but it's still the same concept. It applies to contracts, task orders, delivery orders, solicitations, and modifications thereof for services, including construction, performed in whole or in part in the U.S. or its outlying areas. Same requirements about being issued in new solicitations issued after October 15th, on or after. New task orders, delivery orders awarded on or after November 14th if the solicitation predated October 15th, extensions, renewals, options. The one addition that they had that was not in the FAR council, or I'm sorry, in the FAR deviation, is that they also stated that existing IDIQ contracts where you're anticipated to have orders that exceed the simplified acquisition threshold with an ordering period that extends beyond October 15th should also be modified. So they're saying get at the base IDIQ contract, not just the orders that are going to be issued under the IDIQ contract. They also, rather than saying strongly encourage, DOD used the word may, and that contracting officers may include the clause in those technically non-covered contracts, either because they're under the simplified acquisition threshold, they're for products, or because the time frame hasn't yet come up for the clause to be required. So maybe the Department of Defense is going to take a slightly less aggressive approach, but don't quote me on that. We'll have to see. Also, the class deviation from the Department of Defense made clear that modifications to existing contracts, task orders, and delivery orders shall be done through a bilateral modification. It's really important for contractors that this can't be just added unilaterally. Bilateral modification means the contractor needs to sign off on it. Now, what is the consequence if you don't sign off? We'll talk about that in a little more detail. Maybe you don't get the option exercised. Maybe your contract's not extended. Maybe the government terminates for convenience. It remains to be seen. I think a contractor is going to have more leverage in the may include or strongly encouraged to include type modifications that are requested by the contracting officer instead of the required ones. Also, because it's a bilateral modification, contractors can request equitable adjustments to the contract price or schedule for compliance or for the cost of compliance. Also, I think it's important to note that if it is not required for your contract, but it falls in the may or strongly encouraged category, that gives the contractor a little bit more leeway to negotiate an implementation time frame, because if you think you only have production contracts and it's not going to apply to you, and you curveball of a modification, you might not yet be in a position to be compliant as of the date you sign that modification. Also, it's important to think about what's the impact of signing the modification, not only on your company, but on your key subcontractors. Do you know that they will not accept them, and is that going to cause issues for you? Also, is it going to result in you losing some key personnel or other employees? So again, if it's not required, but just strongly encouraged and it's going to have a significant impact, definitely put together that argument now to have those honest conversations with the contracting officer. Both the FAR and the DFAR, or the FAR and the DOD deviations contain identical FAR and DFAR contract clauses. And those contract clauses, as we predicted, require the contractor to comply with the guidance, including updated guidance and FAQs published by the Safer Federal Workplace Task Force. And I have the website here. As I mentioned, it's difficult to see what's updated. I've been checking it daily, and since the guidance came out, I've seen one new FAQ. Contractors are required to flow this down to subcontracts in any tier if it exceeds $250,000 or for services including construction and performed in whole or in part in the U.S. or its outlying areas. So prime contractors and higher tiered subcontractors are not required to flow down the clause to subcontracts solely for the provision of products. And that's important because if you are a subcontractor, you have no prime contracts, you only sell products, I think that you'd have a basis to push back on an overzealous prime contractor who's trying to flow down the clause to you and insist on your compliance with it. When it comes to what is a higher tier contractor's obligation vis-a-vis a subcontractor, the guidance and a new FAQ came out and made it clear that the obligation is to include the clause in the subcontract. And the only obligation is that you don't have to basically police your subcontractor or get any records of vaccination requirements. And you're allowed to assume your subcontractor is compliant unless you have credible evidence otherwise. So it's important that if there's a report to you that a subcontractor is not compliant or refuses to comply and they fall in that services or construction category, that you follow up and make sure, do we have some credible evidence that they're not compliant, in which case it's not clear what you need to do at that point, but you need to do something. Then you're potentially on the hook for their noncompliance if you remain silent about it. So as I mentioned, we have a lot of open questions. Are blanket purchase agreements covered? Typically, blanket purchase agreements are not technically contracts until there's an order issued under them and the order binding contract. The GSA also issued a class deviation. Of course, the slides went to press before that happened, but in their class deviation, they did mention that blanket purchase agreements should be modified to include the clause. Also, what about GSA multiple award schedule contracts? GSA said that it is too administratively burdensome to figure out which GSA contracts are solely for products versus contain a mix of products and services versus just services. So they are going to issue mass modifications to all GSA multiple award schedule contracts, incorporating the new clause. And if a contractor refuses to accept the mass modification with the new clause, GSA is encouraging contracting officers to basically hide their information in the GSA website or e-portals or e-buy websites so that no further products can be purchased under those contracts. So that GSA taking advantage of the strongly encouraged and making it more administratively or less administratively burdensome from them, but this may result in imposing these requirements on a lot of contractors where they otherwise would not need to comply. It wouldn't be required. It's also unclear right now whether it will apply to other transaction agreements. We just talked about OTAs at length and how those are different and not subject to many procurement requirements, same requirements that apply to cooperative agreements. The definition of contract and contract-like instrument is so broad, it definitely would cover another transaction agreement. It remains to be seen how agencies and departments like DoD will address other transaction agreements. What about the in connection with concept? Is that going to extend to subcontractors? So what about outside legal service providers, outside accountants? Is it going to be extended that far? Or is the in connection with only apply to employees, which makes a lot more sense? Again, this isn't necessarily to make sense. It's more to get everyone vaccinated. We talked about the rights the contractor has with a bilateral modification. I'm not going to go into that. Julia talked at length about bid protests and protesting things in a solicitation. If you see the vaccination clause in a solicitation where it's actually not required and may be grounds for protest, keep in mind, though, that a lot of times at protests, the GAO and Court of Federal Claims are very deferential to the agencies, given the agencies now have the power, and not only may they, but they are strongly encouraged to include the clause, even when it's not a covered contract. It might be an uphill battle to protest the inclusion of the clause in a non-covered contract. What are going to be the potential consequences of noncompliance? Potential withholding of payments, termination for default or cause. Is this going to be seen as material enough to give rise to Civil False Claims Act liability, as Matt talked about earlier? Right now, in the deviations, there is no representation or certification regarding compliance. Will that happen when we see the FAR clause get issued later this week? Also, I think, do I think the government's going to come in and ask for vaccination records about each and every employee on day one? No, I don't. I really see where this coming up is vaccination is a very touchy topic for a lot of individuals, and people feel very strong about it on both sides of the aisle. And I think that where we'll see this is in whistleblower reports about people who you know aren't vaccinated, even though you're in a covered contractor workplace. And then the question comes down to, will the government take into account degrees of compliance or good faith efforts towards compliance? I mean, we have a lot of companies right now are struggling with having enough resources and employees to perform work under their contracts. And now imposing this requirement may result in the loss of additional employees or new hires. So at what point is a 98% compliance threshold enough, 99%? Right now, there's a zero tolerance. I mean, in that they don't give you any outs, but it will remain to be seen how it's going to be enforced. So what do you do now? We're encouraging companies to review your existing contracts, task orders, delivery orders, to determine whether they're covered contracts and when they may be modified to include the vaccination clause. Again, nothing is a covered contract until you have the vaccination clause in it. However, you can anticipate when you might have option exercise or a renewal coming up in something that would otherwise be a covered contract because it's a contract for services, and anticipate that deadline for when everyone needs to be vaccinated, whether it's December 8th or some later date. Also, it's important to start now reviewing all your solicitations you plan to bid on, see if there are any amendments to solicitations to include the clause, determine whether or not those will lead to covered contracts. Again, that's more in your power, whether or not you're bidding on a solicitation that includes the clause. If you determine you either are or will likely become a covered contractor, you need to determine which of your locations are covered contractor workplaces, which employees are going to be covered contractor employees. Start collecting the vaccination information from covered contractor employees, provided it's not precluded by state law. Develop policies, procedures to ensure compliance, including the consequences for employees who refuse to comply, and flow down the clause to applicable lower tier subcontracts. So keep an eye out for the end of this week for the FAR and DFAR clauses that get issued, as well as any potential additional guidance by the FAR Council, and continually check out the task force FAQs for any new information and updates. There was one other topic I wanted to briefly mention, but I think we've received a gazillion bajillion questions I've been talking. So let me see if I can, and some of them may have been answered during the presentation, and I know everyone has a lot of questions on this. It is really a key issue for a lot of companies, and I do want to make sure that we help everyone who has questions. Feel free to reach out to us after the presentation. But I'm going to continue going on, and then I'll circle back to the questions. Because the other requirement, aside from the vaccination requirements, that I think is really important to a lot of clients, and I know it's hard to get our mind off that presentation, small business re-representations. We're very active in the M&A space, and we help companies who are buying or selling government contractors and maneuver through the mergers and acquisitions process. Effective November 16th, 2020, there was a new SBA rule about re-representations for small businesses. And there was a lot of discussion over what happens if you have multiple award contracts and you are small when you got the multiple award contract, but then are later large. Are you eligible for various orders? I'm not going to go into all those details. But I want to focus a little bit more on what happens if you're no longer small because of a merger or acquisition. The standard rule is, and has been, that if an offeror is small at the time it submits its offer, it remains a small business throughout the life of the contract. That's kind of what we've always assumed, and that's what we've gone by. However, if you have a merger or acquisition that makes the company or even the acquirer no longer small, you must recertify within 30 days of the acquisition if a novation is not required, or 30 days after an approved contract novation if a novation is required. At that point, if the company is other than small, the agency can't count orders issued or options exercised to that contract towards its small business contracting goals. So you don't necessarily lose the contract if you already have it. The government can't treat those as small business contracting dollars. With the new part that you want to make sure you're aware of is that if the merger, sale, or acquisition occurs after you submit an offer, but before award, the offeror must certify its size to the contracting officer before award, okay? As long as the merger, sale, or acquisition occurs within 180 days of the date of the offer. And that includes agreements and principles, such as some letters of intent. So if the offeror was small at the time it submitted its offer, It then was acquired by a large business, and the award has not been provided on that contract yet. You need to go to the contracting officer and let them know we are no longer small. If it is a small business set aside, that small business will no longer be eligible to receive that award, provided, again, you're within that 180-day window, okay? So if you are looking to acquire a small business and they have key contracts up for renewal, you might want to make sure you're aware of these requirements before you go ahead with that acquisition. Okay, so let's go to our questions. We have about 10 minutes left, and I'm going to sort through these. And I'm going to look at the vaccination ones while I take advantage of Matt answering this one, which is with respect to the NIST requirements, Matt, that you mentioned, for companies that solely sell COTS, commercially available off-the-shelf items, do they need to comply with those DFAR cybersecurity requirements?
The answer is no, they don't. If the sale is solely for COTS, then the provisions don't apply. You can look at DFAR's section 204.7304, if you're writing down numbers here, as well as the contract clause at 252.204-7012. So if you're solely doing COTS, then you don't have to worry about the cybersecurity self-assessment.
Great. And
back to you, Erin.
Thank you. And I've read through some of these questions on the vaccination front. So one of the questions has to do with, are there any size exceptions? I should have mentioned this requirement for the vaccination clause, it applies to small businesses. So there is no size of the company that's going to be exempt for the requirement. Also, if you have fully remote employees who will not be on site, there's no exemption. Well, they will not be covered contractor workplaces with respect to the social distancing and masking. If you have employees who are working on or in connection with a covered contract, they must be fully vaccinated by the time work starts under that contract, or December 8th, 2021, whichever is later. And there's no exception from those requirements. So the employees who are working remotely won't need to comply, but those who are working remotely who do not work in connection with or on a covered contract will not need to be vaccinated, but the other individuals will. Question if cooperative agreements bound by 2 CFR 200 are exempt. So when I mentioned the vaccination clause, I should have mentioned that for those agencies that have non-FAR-based contracts like cooperative agreements, agencies similarly by Friday are supposed to come out with a contract clause. So cooperative agreements are expressly identified as contract or contract-like instruments. So I am anticipating that we will see a contract clause that will also apply to cooperative agreements come out, even though it's not subject to the FAR. So most of the agreements we talk about are procurement contracts, so we focus a lot on the FAR, but the agencies are supposed to come out with non-FAR-based clauses as well. Do I think that the Supreme Court will weigh in on these requirements? Yes, I do think a lot of these vaccination requirements are going to be subject to legal challenge. I think it's less likely with the government contract requirements only because you don't have to be a government contractor. You don't have to take the government's money, but when you do, you tend to be subject to the government's requirements, and that is one of the levers they have. So I think that it might be more difficult to challenge these for government contractors than for, let's say, other just large businesses who don't do any business with the federal government. There's a question if a lower tier subcontractors to comply if they reside outside the U.S. Again, it does not apply to employees who are outside the U.S. or to work that is solely performed outside the U.S. In terms of what FAR or DFAR clause numbers to look for in the contracts, the deviation clause does have kind of a number with an XXX, but I would say we wait and see too what comes out on Friday from the FAR Council. Question if the vaccination clause is included in the contract, who pays for the compliance? And the answer is it's unclear. It's unclear right now if it's going to be an allowable cost, if the government's going to agree to request for equitable adjustment for costs associated with compliance. You would think on a fixed price contract, it's reasonable to ask for an equitable adjustment before you sign a bilateral modification, because there are additional costs of compliance that you were not aware of at the time you entered into that contract with that fixed price. So that's going to have to be a negotiation with the government. So the question is, do you have to keep a copy of the vaccination card, or can you just establish a method to confirm it exists? You have to have a record of it, and so you need to keep a copy of it. You know, the only thing that's on there that might be quote unquote sensitive would be the employee's date of birth. That's something that HR already has in its records. So as long as you have HR or a private process for collecting those, employees shouldn't have too many concerns about that. There's a question, if there's a subcontract that's not amended by a flow down to include the mandate, does it still apply? Again, it's a covered contract is a contract that includes the clause. So if you do not receive any contracts that include the clause and your contracts are not modified to include the clause, then you do not have any covered contracts. It doesn't just apply by operation of law. Some of these other questions here. There's a question if there's an indication that if the in connection with definition will be used similar to the service contract labor standards where there's like a 20% threshold. Again, right now there's no threshold. They basically say that if it's material to the performance of the contract, then that's the standard. And again, they specifically use billing, legal review, and human resources as examples, which to me I think are pretty broad. So let's see if there's any. Julia, there is a question that says, if time permits, if you want to just some clarification about the Huawei requirements. I know that is not something that we presented on here today, but Julia has done a ton of work in advising clients on those requirements. Julia, do you want to just give an overview of kind of where we stand on those requirements?
Sure. So right now, all federal contracts and most subcontracts have a requirement to comply with what we call the Huawei or covered telecommunications equipment or services clauses. And those generally prohibit providing telecommunications equipment or services from specific Chinese companies to the government. And then for prime contractors, there is a prohibition on using any covered telecommunications or equipment or services from those specific Chinese companies in your business, whether related to government contracts or not. So that's a broader requirement that applies to prime contractors, and then for subcontractors, they're prohibited from providing essentially IT type services or equipment to the government that would have products or services from those prohibited companies.
Thank you, Julia, especially for me putting you on the spot for something that was not your topic today. And we are going to leave that a few minutes early today. Thank you all for attending. I still see that we have some great participation and some very loyal followers who have attended these seminars for many years. Again, hopefully we'll be back in person together next year. Don't forget to please fill out the survey with the extra 2 minutes that I am giving you, as well as you can have a copy of the slides. And this was recorded and it'll be available if you want to pick back up on anything we said or circulate it to any of your colleagues. So I look forward to hearing from you. If you have any questions, feel free to reach out to myself, David, Matt, Julia, or any of your other contacts at Foley. We look forward to working with you. Have a great afternoon.